Recording in progress.
Good morning, Chair. Good morning, honorable members and everyone present in the meeting. Chair, the time is 9 o'clock now, so you may start the meeting. Thank you.
Good morning, honorable members. Nolthanda, are we forming a quorum for the meeting?
Yes, sir.
Yeah. Yeah, thank you very much. Honorable members, this is the continuation of the meetings of yesterday and day before. We're on our last day of our oral hearings. May you flag the agenda? Thank you. Thank you very much. All members, where I am in the Greater Skukuni district, Marble Hall area, Hobokwane, there were severe storms last night, early hours of the morning. So yeah, a lot of people didn't sleep well, and we wish them luck in their recovery of whatever they lost during the storms. You are all welcome. We are continuing with our engagement with the Bella bill. Is there any move for adoption of this agenda? I'm setting up as I'm talking to you. Any move for adoption of the agenda and the program?
Morning, Chair.
Yes.
It's Honorable Nkosi here. Greetings, your good self.
Yes.
All members present in the Zoom meeting. I move for the adoption of the agenda, Chair. Yes, thank you.
Thank you. Any second?
Ndongeni seconds, Chair.
Yes, Honorable Ndongeni, thank you very much. Like I said, we welcome those who are new to the program, our guests. I'm trying to get a list of the yeah, thank you very much. We're welcoming today Cape Home Educators, represented by Mariji Uckerman, and then we have the Selborne Primary School SGB, represented by Mr. Rian Bishop. We have the Laerbur School Alfeld SGB, represented by Mr. JJ Skippers. We have Laerbur School General Albert's Primary, represented by Mr. Martin Pretorius. And we have the Northcliff High School SGB, represented by Mr. Bradley Lee. And we have Independent Micro Schools Education First Research Group, represented by Mayor Janine Texeira. And then we have the Learning Cut Remedial Teaching, represented by Mayor Catherine Kenyon. We have Learn Free, represented by Ndate Christopher Cordeiro. And we have Homeschooling Association South Africa, HSSA, represented by Mayor Rebecca Liebenberg. And we have Let's Do It Together for Education, represented by Mr. Naresh Patel. You are all welcome, and also welcoming those who were with us from the first day. They were in our meeting yesterday. They are still in this hearing again today. We thank you and appreciate your commitment to listening to others and also, hearing what other people are suggesting in terms of the bill. This bill was the bill we're dealing with is referred to as the Bella Bill. It's actually the Basic Education Laws Amendment Bill. That's B2B of 2022, which was introduced to the Select Committee on Education, Technology, Sports, Arts and Culture on the 8th of November 2024. The department took the committee through the clause-by-clause proposed amendments within the bill and the clauses which were amended after the National Assembly public participation process. It is with this background that the NCOP decided to conduct its own public participation to get input from all stakeholders on the amended version of the bill. Since this bill is a Section 76 bill, it was referred to the provincial legislatures to also embark on a public participation process in the provinces, whereby members will eventually return with negotiating mandates from their respective provinces. However, due to the high public interest in this bill, this select committee on the NCOP has also called for the written submissions from the public to provide its input on the bill. Upon receiving the written submissions, we felt that it is also important to invite stakeholders who requested oral submissions in order to listen to their concerns and drive a robust dialogue on this highly, interesting bill. We would therefore like to thank all the organizations to availing yourselves to contribute to the shaping of the future of South African basic education. We hope that these oral hearings will be fruitful and provide a meaningful engagement to yourselves and the committee. Thank you very much. Let me just go straight ahead and invite a representative from Cape Home Educators, Me Mariki Uckerman. Hello?
Sorry, Chair. There's one more organization, Section 27, represented by Mr. Michelle Petha Bridge, and one individual, Miss Tanya Fennis. Chair.
Yeah, those two also will be included in the and they are welcome. I just omitted their name because I think I'm using the old the original paper. Thank you very much. You are all welcome. And can we please give the platform to Cape Home Educators? Ma'am, you've got 30 minutes to make your presentation, to talk to us. Thank you.
Good morning.
Good morning.
I just want to share my screen. Can you see my screen?
Yes, ma'am.
Yes, we do.
All right, thank you. Thank you. Good morning, Honourable Chairperson, Honourable Committee members, and all present. My name is Mariki Uckerman, and I'm the Chairperson for Cape Home Educators. Cape Home Educators, I'm sorry, just want to go to the next slide. There's the agenda. Sorry, I forgot to flight it. Okay. Cape Home Educators was established in 1996 and is a voluntary association that strives to promote home education. The association endeavours to obtain the recognition of society and the protection of the law for the right of children to receive education within the family and for the obligation and the concomitant right of the parents to be able to educate their children in every respect. The association furthermore endeavours to obtain for children the maximum freedom to be educated within the family and community in accordance with the best interest of each child and in line with their own culture and religious beliefs. The association recognizes that the state has a constitutional obligation towards the child to provide education in cases where the parents are unable or unwilling to educate their children themselves. The association recognizes that the parents have a right to dedicate the task of education to persons of their own choice. Cape Home educators, therefore, reject the ballable on the following grounds. There was inadequate engagement. I am grateful that we have this opportunity to consider whether the DBE had engaged with home educators on the ballable. In the PCBE meeting on the 17th of August 2023, Mr. Laerbur claimed that there had been consultations between home educators and the DBE on the ballable. If these meetings were indeed consultations on the bill, one would expect that the ballable would have been on the agenda of these meetings, that copies of the ballable would have been distributed at these meetings, and that inputs on the bill would have been requested. There is a link to the recording of this meeting at the bottom of the slide. I will provide Mr. Laebur's statements first and then respond to it. He said that the first consultation meeting on the review process regarding the policy on home education was held on the 9th and the 10th of October 2014. There were meetings with the home education sector and the DBE in 2014 and 15. These meetings focused on compiling a discussion document that would form the basis for the future policy and law. Although two versions of a draft discussion documents were distributed during these meetings, a final discussion document was never completed or made publicly available for comment, as promised by the Minister. During these meetings, no mention was made that a task team was already drafting the ballable. The home education sector was caught by complete surprise when the ballable was published for public comments by the DBE in 2017. Therefore, these meetings cannot be viewed as consultation on the ballable. The outcome of these meetings was a draft discussion document produced by the DBE's own consultant, Dr. Trevor Coombe, a retired Deputy Director General of the Department of Education. Dr. Coombe produced an excellent document. It provided requirements that had to be created as a condition of a successful consultative relationship. It included the fundamental need for research with a mutually agreed methodology, as well as laying out a process to avoid exactly the situation we have now, with all homeschoolers rejecting the ballable. A working group was established. It held meetings from 2015 until the policy of home education was promulgated in November 2018. There were several fundamental problems with this working group. Dr. Coombe's discussion document was ignored. The need for research identified by Dr. Coombe was ignored. The DBE doesn't even know how many homeschoolers there are. It appeared that the DBE had a predetermined outcome in mind. The DBE's fundamental lack of understanding of home education and failure to implement research led to the inability to find common ground. It might be worth mentioning that there is currently a national task team working on the regulations of home education, and that some of the home educators on that group are very dissatisfied. Some feel they are being co-opted to create the impression of engagement because they do not see the incorporation of their contributions, apparently because the DBE appears to have a predetermined outcome in mind. They also find that the DBE fundamentally lacks an understanding of home education and that they are unable to find common ground. Please take note that there was another working group that worked on the ballable. Home educators did not form part of that group. Mr. Ndebele said on 28 February 2020, the Department of Basic Education hosted a roundtable on the implementation of the policy on home education. In February 2020, a roundtable was held and many representatives from the home education sector were invited. However, This roundtable was about the implementation of the home education policy and not the balanced or the policy itself. This is articulated in the DBE report on the roundtable that states, the roundtable was geared towards strengthening collaboration with the home education community to ensure proper implementation of a policy on home education as set out in the National Education Policy and the South African School Act of 96. Furthermore, home education associations like Cape Home Educators had to write and ask to be allowed to attend this roundtable. In August 2020, follow-up meetings were held about the implementation of the home education policy, the establishment of JLCs, and the National Task Team for Regulations. Since then, a few JLC and NTT meetings were held. However, the objective of the JLCs were generally focused on the implementation of policy. No copies of the bill were distributed at the JLCs, and no input was requested in the bill. The meetings of the NTT had a similar focus, as articulated in the appointment letters that stated, one of the recommendations of the roundtable was the establishment of a task team whose responsibility would be to develop regulations for the policy on home education. The roundtable referred to above proposed the establishment of a task team to develop regulations. The task team was established on 22 June 2022. The task team had 5 meetings since its establishment. However, this is regulations. The bill is taken for granted, not the discussion of the bill. Then he said on the 22nd of September 2020, the Department of Basic Education held a meeting with the South African National Homeschooling Association to discuss issues regarding the implementation of a policy on home education. Again, that was on policy. He said on the 4th of August 2020, the Department of Basic Education held a meeting with the Liberty in Learning Coalition to discuss issues regarding the implementation of a policy on home education. Again, please note that was on policy. The Pestalozzi Trust continued to engage with Advocate Rutman after the publication of the bill in 2017. At various occasions, the Pestalozzi Trust requested Advocate Rutman to arrange a meeting between the task team responsible for the bill and the trust, but such an engagement never realized, even though it was promised by Advocate Rutman. In summary, there were indeed a few meetings between the DBE and home educators, and sometimes these meetings were experienced in a positive light. However, the agendas of his meetings were never about the bill. During none of his meetings was a copy of the bill distributed and inputs requested on the bill. These meetings can therefore not be viewed as consultation on the bill. Mr. Laerbur, however, does not mention the meetings that did take place on the bill. 1. There was a meeting with the Pestalozzi Trust in October 2017, primarily to discuss the logistics of handling the large number of homeschool submissions that crashed the relevant official's laptop and how the Trust could assist to collate responses. 2. In January 2020, the Minister met with the Trust. The Trust was asked to submit comments, which the Trust did, backed by a legal opinion. Some changes were made to the bill as a result, and I will elaborate on this meeting. 3. On 9 January 2021, DB officials met with the Trust to discuss research and the research needs for a comprehensive SAYA. The Pestalozzi Trust provided the list of research needs keyed to the SAYA. The DBE did not respond again. With regards to the meeting between the Pestalozzi Trust and the Minister, there was only one meeting between the Pestalozzi Trust and the Minister on 28 January 2020, where the Trust was given a copy of a bill and was asked to comment. The Trust raised concerns on the following points. 1. The SA Schools Act is inappropriate to regulate home education. This matter was discussed during the meeting. The proposal to regulate home education outside of SASA was not challenged, but it was felt that the bill had progressed too far in order to consider. 2. That education officials must grant permission to choose home education causes tension with other laws. The Trust's submission articulated this as follows. We therefore aver that where the parent makes the decision to home educate, but this decision is not subject to a process of approval by the state, and especially not a process in which an official of his state interposes him or herself between the parent and the child and decides how the child's fundamental right to education ought to be realized, and the parent's fundamental responsibility to guiding, directing, and securing the child's education is exercised. 3. The impact of the home education provisions in the Bala Bill cannot be considered without a fully costed socio-economic impact assessment. 4. It is inappropriate to enforce assessments developed for CAPS in the National Curriculum Statement on a sector that uses a diversity of curriculums. 5. The requirement to register for every phase unfairly discriminates against home learners. This concern was substantiated with a legal opinion that was provided. 6. The home visits provision in the Bala Bill may constitute a breach of the privacy provision in the Constitution. This concern was also substantiated with a legal opinion. The penalty clause, number 7, the penalty clause imposing a potential custodial sentence of a fine and or up to 12 months imprisonment for failure to register for home education is not in the best interest of the children concerned. This concern was also substantiated with a legal opinion. The outcome of this meeting was that the requirement to register for every phase in point 5 above was changed to a once-off registration and then notifications for the subsequent phases. Since this meeting was about the Bala Bill and did result in changes, it was certainly a meaningful engagement. However, this was only a single engagement with one organization. This cannot be viewed as wide consultation with the entire sector. I hope that we can at least agree that there was inadequate engagement. The home education sector experienced that the DBE had a preordained outcome in mind that was largely to implement the Western Cape draft policy on a national level. The Bala Bill will entrench an education system that fails to realize many learners' rights to basic education. It seeks to entrench the current binary education system that only caters to education at school or home, thus ignoring and suppressing innovation in education that would realize the right to a basic education for those that do not fit into the current system, thereby discriminating against and depriving learners of access to basic education. Pretending that the majority of learners are well catered for by the current binary education system not only ignores the school placement crisis, but also the fact that the Bill report indicated that a shocking 81% of learners at grade 4 cannot read for meaning. The Bala Bill places unconstitutional and unfair restrictions on home education, such as compliance to registration and curriculum requirements. In Clause 1, definition, basic education includes grade R to grade 12 as evidenced in the National Curriculum Statement. The proposed definition in the Bala Bill excludes any curriculum of a standard not inferior to the National Curriculum Statement, but that excludes or diverges significantly from the National Curriculum Statement. CHE recommendation is to redefine as basic education means pre-tertiary education and may include education in public schools, independent education, including home education, and other forms of education recognized in legislature. Alternatively, redefine as school education and create a definition in regulations. Basic public school education means grade R to grade 12 as evidenced in the National Curriculum Statement. Whereas the Constitution requires registration for home education with the state, Clause 35 requires obtaining permission from the HOD to be registered for home education. We strongly oppose the imposition of restrictions on children's right to education in terms of Section 29(3) of the Constitution, without considering the relevant factors in Section 36. The Constitution stipulates only one relevant limitation on the right to education, namely, that the quality of education provided must not fall below the standards of comparable public educational institutions. However, Clause 135 impose additional limitations on the right to education for home learners. A. It prohibits the utilization of educational programs that meet or exceed the standards of the national curriculum, but do not cover skills and content comparable with the national curriculum. B. It prohibits the provision of education overseen by the learner's parent if conducted in a more suitable environment outside the learner's home. C. It prohibits the utilization of appropriate tutorial or educational support for all curriculum areas, even if delivered by a certified teacher. CHE recommends that the committee replace Clause 35 with a proposal from the Pestalozzi Trust. The Ballot Bill will impose an inappropriately severe penalty clause and expose home educators to double jeopardy. It intends to maintain the current binary education system by using an inappropriately severe penalty clause to intimidate parents and independent educators into compliance, and furthermore, home educators are exposed to double jeopardy. Clause 2 of the Ballot Bill proposes that the penalty for not complying with the requirements of the SA Schools Act is increased from 6 months to 1 year. This penalty also applies to failing to register for home education. The Pestalozzi Trust objected repeatedly to an inappropriate penalty for mere administrative negligence. In a submission to the Minister in January 2020, the Pestalozzi Trust provided a legal opinion that stated, failure to comply with procedural requirements of Section 51, for example, should not carry a potential custodial sentence of 12 months. This is unreasonable and could never be in the interest of a child, yet that is what the bill, as currently worded, provides. In a feedback presentation by the DBE to the PCBE on the 20th of October 2020, the DBE responded by making the statement, the penalty clause is not specifically targeted at non-registration for home education. This clause is directed at non-attendance at a school. It has been inserted as a deterrent for those parents who fail to send or prevent a child from receiving education. The penalty clause was increased in the bill to provide for not exceeding 12 months, as the existing penalty clause did not serve as a deterrent. However, despite the objections and the admission that the objection is valid, no changes were made to Clause 2, and the Ballot Bill submitted to Parliament in 2022 contained the same penalty. As part of its written submission to the Ballot Bill in 2022, the Pestalozzi Trust provided a more expanded legal opinion, as well as a criminological opinion on this inappropriate penalty clause. In the oral submissions to the PCBE in November 2022, several organizations also objected to the penalty clause, including Christian View, Equal Education, Section 27, Malahambi Seventh-day Adventist Church, Learn Free, and the Legal Resource Center. After the deliberations of the PCBE, stakeholders were given the opportunity to provide inputs for the A-list. Cape Home educators made a proposal to change the penalty for failing to send a child to school to a R2,000 fine, in line with the current Eastern Cape School Education Act. Christian View also made a similar proposal. Despite all these well-reasoned objections, Clause 2 still contains the 1-year imprisonment penalty. This raises the question why the inappropriate penalty clause is retained, while the DBE admits that the penalty clause is not appropriate. A possible answer to this question can be found in the socio-economic impact assessment and can be viewed as the position of the DBE. According to the DBE, homeschooling parents and organizations are dissatisfied with the requirement that they must register their children for home education and the provision of assessment reports by competent assessors, and it is expected that this dissatisfaction will lead to disputes. The DBE proposes to resolve these disputes through mediation and/or institute legal action, litigation in a public court. The SAIA therefore seems to indicate that the DBE knows that home educators will resist the implementation of the Ballot Bill, and it plans to use litigation to coerce compliance with the bill against the will of home educators. Without a stiff penalty, litigation will be very difficult. If that is indeed a correct conclusion from the available facts, then it makes sense that the DBE wants to keep an inappropriate penalty to be used to intimidate parents. Another possible answer relates to clause 33, which increases the penalty of operating an unregistered independent school to 1 year. This seems to indicate that the offence of homeschooling your own children without registration is viewed as similar to operating a school in which you educate other people's children without registration. What effect will clause 2 have on HIV's schools? Children who do not fit into traditional schools, children who thrive with alternative modalities and approaches, learners for whom cottage schools are the only alternative because they don't find school placement. Will micro school operators face a 12-month sentence and a criminal record? The double jeopardy predicament. An underlying problem with home education is that it can be viewed as part of independent schools as well as part of parental care. Whereas schooling is regulated by the SA Schools Act, parental care is governed by the Children's Act. Disputes with the DBE with regards to registration requirements exposes parents to persecution from the Department of Social Development, with social workers threatening to remove children from parental care because they are not attending school. If home education is regulated under the independent education, why is the DSD involved when a home educator fails to be registered? Home educators are exposed to double jeopardy because they can be persecuted by both the DBE and the DSD for the same offence. What might happen if a parent is unable to register for home education due to religious reasons regarding compliance with the contents and skills in the National Curriculum Statement? This vulnerability to prosecution was illustrated in the Doe case. The Doe family of KwaZulu-Natal were finally reunited on the 14th December 2015 after the children had been removed by social workers 8 months previously for not attending school. Their 3 eldest children, of whom the youngest was only 3 years old, were permanently returned to the care of their parents by the Children's Court, which set aside all the previous orders which had caused the children and their parents great heartache. The children had been removed from the family in April 2015. The only reasons given to the court were that the children were not attending schools and that their parents were allegedly indoctrinating the children with their religious beliefs. This original order initiated what Advocate Avril Potgieter described as the most bizarre case he had ever encountered. Advocate Potgieter was the senior of 3 legal representatives engaged by the Pestalozzi Trust to represent the family. The other 2 were Mrs. Paula Bernard and Advocate Dion Shah, who acted as junior to Advocate Potgieter. The court also refused to accept the recommendation of a social worker and other interested parties that the court orders the social worker to supervise the family's homeschooling for a year. The presiding officer on the 14th of December 2015 was the 3rd one since the case had started in April. He commented that there is nothing wrong when parents bring up their children in their own beliefs, and that such an upbringing makes the children better people. He also made it very clear that in his view, these children should never have been before the court in the first place. The matter should have been dealt with by other means. These remarks constitute a serious rebuke to the social workers who had brought the matter to court and had recommended that the children be removed from their parents. I would like to make the case for a new education dispensation. The South African Schools Act regulates schools and a limited form of home education. The education landscape has significantly changed over the last decades. Apart from home education, there's also been an exponential growth of several emerging education modalities. Modalities such as cottage schools, online schools, tutor centers, collaborative home education, and co-work spaces. Home education and these new modalities are interrelated and interdependent. Regulatory reform of one of these modalities cannot be done in isolation. The school system is still the largest, but it is deteriorating. The emerging education modalities are growing fast. There is no regulatory certainty on any of the other modalities despite the existence and evidence of their achievements to serve many learners in accessing a basic education. Section 29(3) of the Constitution states that everyone has the right to establish and maintain at their own expense independent educational institutions that A, do not discriminate on the basis of race, B, are registered with the state, and C, maintain standards that are not inferior to standards comparable at public educational institutions. The Constitution gives the right to establish educational institutions. The National Education Policy Act limits this right to schools only. According to Section 1 of the NEPA, education institution means any school contemplated in the South African Schools Act, 1996. This definition makes it illegal to operate educational institutions that operate significantly different from traditional schools. To realize that right, the right to establish institutions that are very much unlike schools must be acknowledged. Therefore, there is a strong case for a new educational dispensation that will reflect the existing educational landscape, not currently provided for in law, that will support the growth of an enabling educational environment. I think we all agree that South Africa is facing an enormous and urgent educational crisis. Together, we must understand the complexity of our education system from all angles to overcome the challenges. If we embrace all opportunities and enable the private sector to get involved to help shift the system that currently subjects millions of children to an unequal education system, we will be able to collaborate and collectively bring about the systemic change our education sector desperately requires to provide greater access to basic education. The valuable outlaws innovation and effectively criminalize it. We need a new educational dispensation that will reflect and enable new educational modalities to be established, registered, and supported. This will immediately help to solve the school placement crisis, cater to learners with diverse educational needs, broaden opportunities for early childhood development, and enable and protect edupreneurs to establish educational institutions. An appropriate regulatory framework requires that the law used to regulate something must be designed for the thing it regulates. According to its preamble, the SASSA was designed to regulate schools. However, home education and emerging education modalities are fundamentally different from school education. Therefore, home education is regulated by a law designed not for home education. It's like regulating bicycle transport by means of the Trains Act. We need to have a broader societal-level conversation about what it means to be educated now and whether what we are doing is fit for purpose in the 21st century. Sorry, I went one too far. It would be an incredible loss if the DBE did not see the opportunity and value of progression and agility that the development of online schooling, home education, and emerging education modalities, such as cottage and micro schools and learning centers bring. If a department does not take the time and the effort to understand the possibilities clearly, they will perpetuate old problems and failures into new opportunities. Unless the DBE seeks ways to enable and partner with the private sector in finding solutions to accommodate learners, we will continue to discriminate against and disadvantage learners in obtaining a basic education. Now is the time and the opportunity to seek educational solutions to educational problems. Through thorough research into the practice and reality of home education and emerging education modalities, and to reflect that into legislation and regulation that will be in the best interest of a child in obtaining a basic education by drafting regulations that mirror and will enable the practical reality of independent educational institutions, instead of providing legislative solutions in service of bureaucratic administrative systems. Home educators have asked the Pestalozzi Trust to develop a proposal for the NCOP phase that protects their rights, but is also constitutionally sound so that it can't be easily dismissed. The Pestalozzi Trust made their presentation yesterday, and I will move on to the next slide. Cape Home educators thus requests that the NCOP will consider and adapt the definitions that will affect home education.
As you watch your time also, ma'am.
I will just quickly finish. Sorry.
Thank
CHE
you.
thus requests that the NCOP will consider and adapt the definitions that would affect home education to become fit for purpose, and furthermore to delete clause 35 from the bill and accept the proposal from the Pestalozzi Trust in the interim, whilst developing a new regulatory framework. The formulation of the Pestalozzi Trust proposal is designed to protect the rights and freedoms of the home education sector and to allow the continued growth of the sector. Furthermore, CHE hopes that the committee will consider legislation that will make education compulsory, not schooling, as compulsory schooling in South Africa failed 81% of school-going grade 4s who cannot even read for meaning. This is indicative that drastic regulatory reform is urgently needed. Thank you for considering CHE's submission.
Thank you very much, Mayor Ukerman. Honourable members, that's the input from Cape Home educators. Are there points of clarity that members would like to ask, seek from the presenter? There's none. Thank you very much for availing yourselves and making time to come and address us on this important matter of basic education, our children. Thank you very much. I'll call upon the second speaker will be Selborne Primary School SGB. They are represented by Ntateri Bishop. Over to you, Rep. Bishop.
Good morning, Honourable Chair. With your permission, I'm just going to share my screen.
You're welcome.
Good morning, Honourable Chairperson and members of the Select Committee. It is an absolute privilege to be here today, and I thank you for this opportunity. I must admit that I'm daunted at the prospect of speaking here today for two reasons. The first reason is that I'm speaking to members of Parliament. The second reason is that when I looked at the list of those chosen to present, they all represented influential groups within the sphere of education. I am, however, representing a small school in East London, and I see myself as an everyday person. But perhaps that is the point. An opportunity to present to the honourable members of the Select Committee for the people, by the people, as the expression goes. Today, I am representing Selborne Primary SGB. We are a small monastic boys' school in East London, in the beautiful Eastern Cape. We are proudly South African school, and I am presenting to you our thoughts on the Bill. Let me start by saying that it is definitely time to amend the Schools Act. This is long overdue. As an SGB, there are many parts of the amendments that we are in favour of, and I take this opportunity to highlight to the committee just three. Firstly, I highlight Clause 2, which amends Section 3 of the Act with reference to the making of Grade R compulsory. As a side note, we are concerned about the funding of this, but in essence, we support the idea. Does the department have the funds to provide facilities, resources, and human resources for making these grades compulsory is an important question to have. Should the department be unable to make these facilities available with resources, then it would find parents guilty of Section 3 of the Act, which criminalises non-attendance at school. However, in essence, as an SGB, we believe that making this grade compulsory is critical for formalising education at this grade. This will have a massive impact on education in our country as a whole. We are also in favour of Clause 22, which amends Section 28 with regards to the national and uniform standards of the SGB elections. This will again remove any uncertainty and certainly set the standard for all the SGBs around the country. We are also in favour of Clause 36, which amends Section 59 of the South African Schools Act with reference to the provision of false information. From our SGB point of view, this will greatly assist schools when parents provide false information in order to gain admissions into our school. However, there are several clauses that we are not comfortable with. These clauses include Clause 4 regarding the amendment of Section 5 with reference to admissions policy, Clause 5 regarding the amendment of Section 6 with reference to the language policy of the school, Clause 14 regarding the amendment of Section 21 with reference to central procurement, and Clauses 34 and 36 regarding the amendment of Section 43 and 48 with reference to the submission of quarterly financial reports to the Department of Education. The Selborne Primary SGB objects to these clauses on the basis of two principles, namely democracy and capacity. In our country, we have one of the best democracies in the world. The theory of role players having a say in the running of their country is something to be proud of. This has influenced all spheres of life, including education. Schools have, since the South African Schools Act, allowed parents as role players to have a voice in the governance of their schools. By centralizing power that was once in the hands of the SGB, this would, in effect, prohibit their democratic rights to play a role in the education and choice of education for their children. South Africa continues to lead the world on democratic principles. In countries like the UK, where centralization has previously been policy, those departments in those countries have been moving towards a decentralization of power. In research, they often quote the South African experience. It makes no sense to us as to why we would now reduce what has clearly worked and has influenced many countries in the world to follow. In research published by Brian Caldwell in 2008, he suggested that decentralization played a large role in establishing successful schools. He said that schools that allowed more say from SGBs were effective and efficient. This was largely in line with international experience. On the screen, honourable members, I share 3 points from Brian Caldwell's research. Based on these comments alone, it should remain our democratic rights to formulate the policies for our school. The fact that we are required to submit this to the department for approval on its own is not problematic. However, the concept of an HOD in any province can sit in an office somewhere and make a decision on policies of a school is far removed from practicality. The HOD does not have the intimate understanding of the unique circumstances and needs of each school. This threatens to strip away the individual identity of schools like Selborne Primary, undermining the autonomy and local context that are crucial for effective educational governance. The biggest point for us as a school is that we are a juristic person as established in the South African Schools Act in Section 15. As a school, over and above this fact, we each have our own identity and our own ethos. This is what attracts parents to join our school, to seek admission. Our parents form our community and they are a large part of who we are. By centralizing these decisions, we risk a single person or a position sitting somewhere far away making decisions about a school they know nothing about. This will ultimately destroy our school. As an SGB, we believe the proposed amendments to Section 5 of the Act are aimed at pressuring schools to admitting more learners into already capable schools, rather than the department constructing additional schools to accommodate the surplus of learners. The fact is that this would create overcrowding in our school. This would infringe upon the rights of the learners already in our school. The school and its parents have a right to choose what they want or deem as quality for their children. They choose our school because of the quality of education we offer, and by allowing the HOD to determine admissions, this will infringe upon their rights. Further to this, whilst there are norms and standards, the HOD does not necessarily know the information about each individual school. I know that it seems reasonable to assume that because schools complete paperwork with regards to information, that perhaps the HOD will know the situation in our schools. However, we submit the same information every year. To us, this indicates that the department does not take note of the information, despite having it at hand. In my school, our classrooms are already full, and built in the 1960s, we cannot accommodate many more learners. Further to this, the school is in an urban centre in the suburb. We are locked in, and there's no further room for physical growth. It would best serve our learners for admissions policies to remain under the jurisdiction of our SGB, as they know the school and its exact situation. This is the democratic right of the school and its parents. It is on similar principles that we object to the amendments to Clause 5 with regards to the language policy. Our parents have chosen our school for its language. Amending this policy will influence the school and affect the rights of our parents. The amendments again reference the fact that the HOD may make suggestions based on the broader community in the district in which the school is situated. As an English medium school, we do not presently have the facilities such as classrooms to add to any additional mediums of instruction. We do not have the human resources to add any additional mediums of instruction or to change our current medium, and neither do we have the resources to cope with these potential amendments. Presently, we are unable to fill our allocation of posts as provided for in the PPN. The ECDOE will allow you to only fill a post if someone leaves or retires from the department and your post is deemed critical. In our area, I can share that there are some schools that have been short of teachers for years. One school has had 6 vacancies and another has had 8. Personally, our SGB has been carrying 2 posts for a while now. Presently, the committee will be aware will be unaware that last year the ECDOE did not pay us the funds we were due with regards to our tranche payments. Schools in our district received only 66% of the allocated funds, with the department retaining 34%. To us, this proves that the department does not have the funds available to implement these changes, should it so wish. Based on this, the Selborne Primary SGB objects to these amendments of these clauses. It is our democratic right to govern the admissions policies as well as the language of teaching and learning in our schools. It is also our parents' constitutional right to make decisions in the best interests of their children. With regards to the amendments in clauses 34 and 36, we submit the following to the committee. Each and every term, we are required to submit numerous documents to the Department of Education. This is over and above the requirements in the Schools Act, such as an academic report and a school improvement plan. At the end of 2023, our school had to submit 15 different reports and/or checklists to our local department. The amount of work that goes into each of these documents is not simple. This does not include the schedules that need to be prepared, academic meetings that need to take place to discuss flag learners, and plans put in place to assist these flag learners. Over and above this, we have the normal everyday tasks that each of our schools require us to perform to effectively and efficiently run our schools. Adding to this significantly would increase the burden on our schools and its resources. All schools, as governed by the South African Schools Act, submit an AFS, an audited financial statement, every year. This is a comprehensive report on the finances of each school. Asking schools to submit quarterly reports on its finances would significantly burden the school and place unnecessary pressure on staff and already strained financial resources. As an SGB, we also ask, why does the department need this additional information? Therefore, we do not endorse the proposal to amend sections 43 and 48 of the Schools Act. The final clause that the SGB objects to is that of central procurement. In the Eastern Cape, the procurement of textbooks has already been centralized, and we are not allowed to opt out. As an SGB, we object to this due to the fact that the department provides so little funds for a school like ours. The fact that we can possibly purchase one grade's worth of textbooks, and most of the time not even for the entire grade, means that the SGB is forced into supplementing textbook orders. This means that the parents, through school fees, are required to purchase additional textbooks. This creates an administrative nightmare for schools, having to complete two different procurement systems, one through the department and one through our own internal mechanisms. However, far more practical objections are that the department hasn't the capacity to deal with this. In 2021, our LTSM arrived only on the 28th of January for that year. This is long after schools had started. Fortunately, as a school, we have been permitted to opt out of stationery centralization to date, and we are grateful for this. Centralization of this process will remove our rights to procure our own stationery at the quality that our parents have come to expect. I can share with the committee that in our circuit, even the quintile 1, 2, and 3 schools complain about the quality of the products that they have received. They too have asked for the option of opting out, as the quality is simply not good enough. Quality is better than quantity. Further to that, asking a grade 1 learner to write his or her name on an LTSM distribution register as proof that he has received one ruler, one pencil, and a sharpener from the department is very difficult to comprehend. With regards to the second point of our presentation, this falls under the broad principle of capacity. Again, the second part references the same clauses that have been objected to already. The Department of Basic Education in the Eastern Cape does not have the capacity to deal with its everyday functions, let alone these potential additional responsibilities. I will provide the committee with numerous examples of where the department has failed to communicate with us timelessly, or even communicated at all. A week ago, I asked the department where I had to submit my concessions. The deadline was the 28th of February, and with the change to a CMC model in the Eastern Cape, we were informed that everything had to go to our CMC. I contacted my CMC, Circuit Management Centre, and asked if I had to submit the documents to them. To date, I have not yet had a response. This was critical documentation that would have granted our boys concessions to aid them with getting through tests and formal assessments at school. It would have assisted those very vulnerable boys with barriers to learning. However, no response. Fortunately, honourable members, I took it upon myself to drive to the district office and still managed to submit timelessly. But the point is that the department has not yet responded to my query. At the same time, I queried the documentation required for termly submissions. Each term in the Eastern Cape, we submit an SGB functionality tool, as well as SMT building blocks. Each term, I complete the documents timelessly and submit, only to be told or informed that we have used the incorrect documents. The department is forever making subtle edits or changes to these documents and sending them out to us after they are due. Then we have to jump through numerous hoops to become compliant despite the late arrival of the incorrect documents. This term, in an effort to prevent needless work by completing the wrong documents, I again contacted my department to ask for the most recent versions of these documents so that I may complete them timelessly. Time is running out as we have a week and a half left of school. I still have not had a response. On the 27th of February at 18:53 at night, I received a memo from the department via WhatsApp. It informed me that at least one member of our SGB had to be present at the training the next morning at 9 o'clock. To us, this again demonstrates that we do not have the capacity to handle our core day-to-day tasks, let alone any of these additional bigger decisions. My SGB consists of attorneys, chartered accountants, heads of businesses, and quantity surveyors. They cannot attend important meetings at such late notice. On Monday, the 4th of March, at 8:18, I received a message about QMS meeting the next day. The WhatsApp read that this was a reminder about the meeting. However, to date, we still haven't received the first notification, so I'm not sure how we can get a reminder. Further to that, on that same day, I was an electoral officer at the crucial SGB elections that are currently happening around the country. Clearly, there was a clash with regards to these requirements, as I was required to be in two places at once. On the 27th of February, the department sent a WhatsApp at 6:20 in the morning, informing schools that they needed to complete a document by 10 o'clock that day if they wanted to be considered to receive a grade R teacher. Never mind that this is 7 weeks after school has already started. To schools that were desperate, they would have had to drop everything to complete a document that again would be crucial for teaching and learning for those learners. My final point with regards to the capacity of my province has to do with our current SGB elections. The Honourable Minister of Education declared the SGB election dates to be in the month of March this year. This was gazetted as far back as the 5th of June in 2023. A memo from our Honourable MEC for Education was only signed on the 12th of February, providing the Eastern Cape with regulations for this election. The memo reached schools on the 15th of February 2024. In the regulations, it stated that schools had to submit their mode of elections to the HOD or their representative with 30 days' notice. Impossible to comply if you consider and look at these dates. This was expected or demanded in clause 11.2 of the regulations. Further to that, the HOD had 14 days to respond to the submissions. Clearly, this hasn't happened yet either. In both of these regulations, as well as the South African Schools Act, it refers to 14 days notice to parents of the upcoming elections. If you do the calculations, combined with the fact that schools close on the 20th of March, it's almost impossible to comply. Fortunately, my school was able to provide notice to parents irrespective of the late arrival of the regulations, as we were working off the Gazette of the Honourable Minister. I must be honest, Honourable Members, that our district are trying their best, and they are full of good people trying to work hard for the benefit of our communities. However, there are plenty more examples like that every year, where we are given information at the last minute. Further to that, we often or seldom receive replies to our queries or emails. To us, as an SGB, this is indicative that the ECDO is not currently coping with their expectations adequately. We therefore question whether they would have the capacity to cope with these additional expectations as proposed in the amendment to the Bill Act, in the Bill Bill. One final suggestion that I have is that in the South African Schools Act, it allows for the HOD to remove the powers of an SGB that is underperforming. However, what if we do something completely different? What if we allow the status quo to remain, with the added privilege of allowing parents in the community to play a greater role in schools? What if we allow parents to play a greater role in enhancing the powers of the SGBs in high-performing schools? What if we allow them to have more of a say in how their schools are run? Honourable Members, I end with a famous African proverb that says, "It takes a village to raise a child." On behalf of our SGB, our village, we appeal to the committee to, rather than remove the powers of the SGB, to provide a system to enhance the functioning of high-performing schools and school governing bodies. Honourable Members, it was a real privilege to address you on this platform today, and for my school to play a small part in the legislative process. We sincerely thank you for your time and for the due consideration that you have given and will give to this amendment. We pray that democracy triumphs in the best interest of our school and of the learners that we serve. Thank you.
Thank you very much, Ntate Rian Boshoff. Yeah, thank you. Thanks for upgrading yourself and for making this input as a contribution towards reshaping our basic education sphere. We'll call upon, or are there points of clarity that members would like to seek clarity-seeking questions? Dr. Boshoff won't be there when we discuss this. In the absence of any, I don't see any from my. Let's thank you, Rep. for making time from your busy schedule to come and engage with us on this Parliament's platform. Thank you very much. We'll invite the Laerbur School Alfeld SGB from Ndate JJ Skippers. Skippers.
Thank you, Chair.
Yeah.
Let me just share my screen here.
Yeah.
There we go. Good afternoon, esteemed members of the committee. My name is Joshua Skippers, an admitted attorney and partner at the Toy Smuts and Partners Attorneys. Additionally, I have the honor of serving as the chairperson on the school governing body of Laerbur Alfeld, a multiracial parallel medium primary school with roughly 1,200 learners. With a personal connection deeply rooted in the institution, as all 4 of my children have attended and are still attending Laerbur Alfeld since 2014. I have been privileged to contribute to its development for over a decade, serving on the SGB for the past 7 years. Today, I am before you representing the collective voice of our school community and governing body, as we aim to provide a thorough oral submission regarding the proposed amendments to the South African Schools Act 1996, as outlined in the ballot. Our engagement stems from a profound dedication to the welfare and educational advancement of our learners. We are grateful for the opportunity to contribute to this important discourse and offer insights into the potential implications of the proposed changes and whether it will contribute to the quality of education in our school and the province of Mpumalanga. In our written submissions, we have articulated several key concerns regarding the proposed amendments to the South African Schools Act 1996, as presented in the ballot. Our submissions highlight objections to specific clauses, including Clause 4 pertaining to the admission policy of public schools, Clause 5 addressing language policy, Clause 16 concerning the powers of the school governing bodies in procurement, and Clause 34 mandating quarterly financial reporting. Additionally, we express our support for certain proposed changes outlined in the ballot. Throughout this presentation, we will delve into each of these areas, providing detailed insights into the potential implications for Laerbur Alfeld and similar institutions, and advocating for amendments that prioritize the welfare and educational development of our learners. The primary objective of this presentation is to critically evaluate the proposed amendments to the Basic Education Laws Amendment Bill and their potential impact on the quality of education at Laerbur Alfeld and within the province of Mpumalanga. We aim to achieve the objective by highlighting specific concerns raised in our written submissions, supported by evidence from the grassroots level of our school. Additionally, we seek to propose alternative solutions where necessary and advocate for changes that prioritize the welfare and educational development of our learners. In our educational landscape, the concerns raised in Clause 4 of the Basic Education Laws Amendment Bill directly impact all 3,775 public schools within the province of Mpumalanga, including those in the Mbombela circuit. Like Laerbur Alfeld, these schools operate within a collaborative framework facilitated by circuit admissions committees to ensure fair placement of learners. The proposed amendments of Clause 4 pose a significant threat to this collaborative approach by granting the provincial HOD final authority over admissions. This centralized decision-making process undermines the effectiveness of circuit admissions committees, which have been instrumental in ensuring equitable access to education for all learners within the community. Moreover, the bureaucratic hurdles introduced by Clause 4 could impede the timely and efficient placement of learners across the 3,775 public schools in Mpumalanga. This administrative burden not only affects admissions, but also impacts critical aspects of school management, such as staff appointments, infrastructure development, and learners' discipline. By relinquishing admission authority to the HOD, Clause 4 compromises the autonomy of governing bodies across all schools in Mpumalanga, not just Laerbur Alfeld. It disrupts the delicate balance of power envisaged by the Constitution, impacting the collaborative partnership between governing bodies, the HOD, and the Minister. In light of these concerns, it is crucial for all schools within the Mpumalanga province to oppose Clause 4 of the ballot and advocate for its complete removal. Maintaining local control over admission policies is essential for safeguarding the quality of education and fostering a sense of community ownership within all 3,775 public schools in the province. At Laerbur Alfeld and within the Mbombela circuit, the admissions process is not merely administrative, but imbued with complex challenges that directly impact the quality and integrity of our educational system. Our school receives 200 to 250 applications annually for admissions to grade 1, while our capacity allows for only 160 learners to enroll. In adherence to the constitutional judgment in FETSAS versus Gauteng Department of Education, our school has established a fair admission criterion based on a determined feeding area, which serves as the basis for determining admissions. Additionally, the information provided by parents is verified accordingly. One significant issue we face annually is the submission of fraudulent information by applicants seeking admission. This problem has become so pervasive that our school principal personally conducts unannounced house visits to verify addresses provided by applicants. In the past year alone, our principal has undertaken over 120 such visits, aiming to ensure that applicants indeed reside within the feeder area of the school. Shockingly, many applicants are found to have supplied false information and documentation, revealing a systematic issue that undermines the integrity of the admissions process. The consequences of such fraudulent practices extend beyond administrative inconvenience. Admissions decisions become fraught with racial tensions, as transparent and diligent handling of applications is essential to combat accusations of bias or favoritism. We have encountered situations where even departmental officials within the education department, including one working in the highest office of the Mpumalanga Department of Education, to which the bill aims to give more control, have supplied false information to multiple schools in a bid to secure admission for the official's child, as seen on the slideshow, showing parts of an official report sent to the department. This flagrant abuse of the system not only undermines the credibility of the admissions process, but also erodes trust in educational institutions and their leadership. In the face of these challenges, it is imperative that admissions policies remain under the jurisdiction of governing bodies, familiar with the local context and intricacies of their respective communities. Granting final admissions authority to the provincial head, as proposed by Clause 4, would only exacerbate these issues. The provincial department, already burdened with numerous responsibilities, cannot be expected to conduct address verifications for each school's feeder area effectively. This lack of oversight would only perpetuate the prevalence of fraudulent practices and compromise the integrity of the admissions process further. In light of these realities, Laerbur Alfeld staunchly opposes Clause 4 of the ballot, as it fails to address the fundamental challenges faced at the grassroots level of our educational system. We urge the committee to consider the practical implications of this clause and uphold the autonomy of governing bodies in admissions decisions to ensure the integrity and fairness of our educational system. Another pressing issue facing Laerbur Alfeld and primary schools in Mbombela is the chronic delay in the construction projects promised by educational authorities. In August 2019, The Education MEC Bonakele Majuba announced plans to eradicate asbestos classrooms and provide additional classrooms to primary schools in Mbombela, including a project at Laerbur Alfeld consisting of the removal of 5 asbestos classrooms and the construction of an additional 8 classrooms. However, despite assurances of completion by the end of 2021, this construction project remains unfinished, with an estimated completion date pushed to July 2024. The implications of this delay are severe. The school governing body made the difficult decision to accommodate additional learners when construction began in 2020, utilizing temporary facilities such as mobile classrooms, the school hall, Laerbur, garages, and the staff room. This temporary solution allowed the school to continue admitting learners while awaiting the completion of the new classrooms. However, this situation has led to significant disruptions in the learner environment. Learners who were initially placed in temporary facilities in 2020 will now have spent 4 years in makeshift classrooms before moving to their intended learning spaces. Moreover, once the construction project is finally completed, there will be no additional classrooms available to accommodate new learners, as all available spaces have already been repurposed for teaching. These construction delays not only hinder the school's ability to provide adequate learning spaces, but also strain resources and compromise the quality of education. Granting final admission authority to the provincial HOD under Clause 4 exacerbate these challenges by further centralizing decision-making and potentially overlooking the urgent needs of schools experiencing infrastructure deficits. In light of these circumstances, Laerbur Alfeld adamantly opposes Clause 4 of the ballot. We urge the committee to consider the practical implications of construction delays and uphold the autonomy of governing bodies in admissions decisions to ensure equitable access to quality education for all learners. Adding to the challenges faced by Laerbur Alfeld in other schools in Mbombela is the failure of educational authorities to fulfill promises of new school constructions, exacerbating the issue of overcrowding. Laerbur Alfeld was the last public school to be built in town of Mbombela 42 years ago. New schools were mentioned in 4 budget speeches in the past, one of which was in 2019 when the Education MEC announced plans for the construction of a primary and high school in Mbombela, slated for completion in 2020-2021 and 2021-2022 financial years, respectively. However, to date, no progress has been made on these promised schools. Not a single piece of land has been touched, nor has a foundation been laid for their construction. A high court, the University of Mpumalanga, as well as a parliamentarian village were, however, built in the city of Mbombela. Mbombela has also seen a big redeployment of the SANDF members back into town. All of these developments with not a single new school to accommodate the influx of families. Furthermore, during a recent meeting between the Acting Deputy Director of Education and the Laerbur Alfeld School Governing Body, it was revealed that officials from the department were not even aware of a feasibility report conducted by the Department of Human Settlements. This report indicated that land allocation for a high school was 100% completed by the city of Mbombela, awaiting only confirmation of funding from relevant institutions. The provincial department's lack of awareness of ongoing projects, despite an EMIS number already being allocated to the school, underscores the bureaucratic inefficiencies plaguing the education system. It is deeply concerning that the same provincial department that announces new schools in the capital city of the province is unable to effectively manage ongoing projects or even be aware of critical developments. This raises serious doubts about the department's capacity to handle additional responsibilities, as proposed under Clause 4 of the ballot. Granting final admission authority to the provincial HOD would only further centralize decision-making power, potentially perpetuating the cycle of bureaucratic inefficiency and failed promises. In light of these revelations, Laerbur Alfeld firmly opposes Clause 4 of the ballot. We urge the committee to consider the department's track record of unfulfilled promises and bureaucratic shortcomings when deliberating on the proposed amendments. Retaining local control over admission policies is essential to ensure that overcrowded schools are not further burdened, becoming unable to provide quality education, and that promises of new school constructions are fulfilled as budgeted for rather than perpetually deferred. School's governing body of Laerbur Alfeld took proactive measures to assess the school's capacity in relation to norm standards and building regulations, contracting the services of a professional occupational health and safety company. A comprehensive report was compiled and submitted to the district and provincial education departments. Despite repeated attempts by the SGB to engage with the department regarding the report's findings, as seen on the slide, no response has been forthcoming. Instead, the school only receives instructions to admit more learners beyond its capacity. The report's findings highlight critical considerations that must be addressed before determining the school's capacity. Notably, projections indicate that the school will struggle to accommodate the projected influx of new learners in the coming years, with grade 1 enrollments consistently surpassing grade 7 departures annually. This imbalance in grade enrollments poses significant challenges to the school's capacity planning efforts. Moreover, their safety risk assessment identified several areas of concern, particularly regarding traffic management, facility utilization, playground capacity, and classroom availability. Of particular concern are the risks associated with traffic congestion during peak hours, as well as the wear and tear on buildings resulting from overcrowding. The report underscores that the school was not originally designed to accommodate the current learner population, falling significantly short of building regulations and national minimum norms and standards for school infrastructure. According to the Occupational Health and Safety Assessment, the school's maximum capacity, accounting for growth projection and specialized subject requirements, is determined to be 700 learners. However, with the current enrollment already surpassing this figure and no immediate plans to expand infrastructure, the report strongly cautions against further enrollment. Expanding on the existing infrastructure would encroach upon already overcrowded playgrounds and recreational spaces, posing further challenges to learner safety and well-being. Considering the risks associated with overpopulation, the SGB asserts that it would be in the best interest of both the school and its learners to refrain from enrolling additional learners. In light of these findings and recommendations, the SGB urges the committee to consider the practical implications of overpopulation and infrastructure deficits when deliberating on Clause 4 of the BALOP. Retaining local control over admission policies is essential to ensure the safety, well-being, and educational outcomes of all learners. Despite the clear capacity constraints outlined in the report and the repeated attempts by the SGB to engage with the department, including sending letters regarding the findings, the promises of new schools have yet to materialize. This failure to address infrastructure deficits directly impacts the school's ability to accommodate additional learners. In the absence of concrete solutions from the department, the provincial HOD continues to issue instructions, as seen on the slide, to circuit managers and school principals to accommodate unplaced learners, disregarding the capacity limitations outlined in the report, placing undue pressure on school principals to manage a situation that exceeds the school's capacity. What is particularly concerning is the lack of engagement and consultation with the school governing bodies on this matter. Despite their explicit mandate under the South African Schools Act to oversee admissions, the unilateral actions by the HOD not only undermine the authority of the SGB, but also exacerbate the challenges faced by schools in managing overcrowding and ensuring the safety and well-being of learners. This continued disregard for the capacity limitations and the autonomy of SGBs in admission decisions highlights a fundamental flaw in the proposed amendments under Clause 4 of the BALOP. Granting final admission authority to the HOD further centralizes decision-making power, perpetuating a cycle of bureaucratic inefficiency and undermining the collaborative governance framework envisioned by the South African Schools Act. In light of these ongoing challenges and the department's failure to address infrastructure deficits, the SGB reaffirms its opposition to Clause 4 of the BALOP. Local control over admission policies must be preserved to ensure that decisions align with the best interest of the school community and the safety and well-being of learners remain paramount. Clause 5 of the BELAP introduces significant concerns regarding language policies at Laerbur Alfeld and the other schools in Mpumalanga. Laerbur Alfeld, as a parallel medium school offering teaching in both Afrikaans and English, faces unique challenges in maintaining its language policy under the proposed amendments. This potential requirement for provincial head of department approval of language policies threatened to disrupt the carefully crafted language instruction framework established by the school governing body. This interference could compromise the school's ability to provide quality education tailored to the linguistic needs of its diverse learner body. Additionally, the proposed centralization of language policy decisions undermines the autonomy of individual schools and neglect the linguistic and cultural diversity that characterizes the educational landscape of Mpumalanga. Laerbur Alfeld serves as a prime example illustrating the challenges posed by Clause 5 of the BELAP, particularly concerning language instruction and infrastructure limitations. As one of the 3 primary schools in Mbombela offering teaching in both Afrikaans and English, Laerbur Alfeld plays a vital role in providing bilingual education to its learners. As the only Afrikaans and English primary school situated in the western part of the capital city, the school serves a diverse learner population, reflecting the linguistic and cultural richness of the region. However, the proposed amendments to language policy threaten to undermine the school's ability to maintain its parallel medium instruction model. With limited infrastructure and resources, accommodating the proposed changes would strain the school's capacity and compromise the quality of education offered. This real-world scenario highlights the urgent need for a nuanced approach to language policy that respects the autonomy of the individual schools and acknowledges the linguistic diversity inherent in South African education. Clause 16 of the BELAP raises significant concerns regarding the autonomy of governing bodies, such as Laerbur Alfeld. Under this clause, there is a potential loss of authority for school governing bodies in procurement decisions, particularly concerning the acquisition of learner and teaching support materials. As can be seen in the slide, parents together with the schools already disagreed with the education department on the curriculum needs and what was provided for by the department. Granting the provincial head of department centralized power over procurement undermines the SGB's ability to make informed decisions tailored to the unique needs of the school community. This shift in authority not only disregard the collaborative governance structure outlined in the South African Schools Act, but also threatens to disrupt the efficient allocation of resources at the school level. By centralizing procurement decisions, Clause 16 may result in bureaucratic inefficiencies and hinder the effective management of school resources, ultimately compromising the quality of education provided by institutions like Laerbur Alfeld. Historically, the SGB has been responsible for procurement processes, ensuring that learner and teaching support materials are acquired efficiently and in line with the school's education objectives. However, under the proposed amendments, the provincial HOD would gain centralized authority over procurement decisions, bypassing the SGB's input and expertise. This scenario poses significant challenges for Laerbur Alfeld, where the SGB's intimate knowledge of the school's needs and priorities informs procurement strategies. Without SGB involvement, there is a risk of misalignment between the procurement decision and the school's educational goals, potentially leading to inefficiencies and resource mismanagement. By highlighting this example, it becomes evident that Clause 16 undermines the autonomy of governing bodies and threatens to disrupt the effective management of resources at schools like Laerbur Alfeld. Laerbur Alfeld contends that the potential risk and challenges associated with Clause 16 necessitate a re-evaluation of this provision. The proposed subsection should be deleted unless it incorporates a provision allowing public schools the voluntary option to opt in to this method of acquiring LTSM. Laerbur Alfeld expresses strong reservations regarding Clause 34 of the BELAP, which proposes amendments to Section 43 of the South African Schools Act, mandating governing bodies to submit quarterly reports on income and expenses. The proposed amendment mandates governing bodies to submit detailed quarterly reports on income and expenses with a tight time frame, adding to the administrative burden already borne by schools. While the aim may be to enhance financial transparency, the practical implications of this clause could severely strain the financial and administrative capacity of schools. Given the existing constraints on resources and staffing, particularly concerning administrative personnel, the additional workload posed by quarterly reporting threatens to overwhelm governing bodies like Laerbur Alfeld. According to the post-provisioning norm, Laerbur Alfeld qualifies for 3 admin clerk posts, but due to a moratorium that was introduced more than a decade ago, only 1 admin clerk is being remunerated by the department. As such, there is a pressing need to reconsider the inclusion of Clause 34. Rather have schools that did not submit audited financial statements for the previous 2 years or received qualified audits for 2 years in a row to comply with this clause. We support. Laerbur Alfeld unequivocally supports Clause 2A, which aims to make Grade R education compulsory. Laerbur Alfeld expresses full support for Clause 19, which empowers the Minister to promulgate uniform and national measures governing the election of members of governing bodies. And Laerbur Alfeld supports Clause 38, which proposes the criminalization of providing false information to schools by parents. As per the case explained earlier, this clause will assist in finalizing admissions promptly. In conclusion, the presentation has highlighted significant concerns regarding the Basic Education Laws Amendment and its potential implications for schools like Laerbur Alfeld. We have firmly articulated objections to specific clauses, emphasizing the threat they pose to the quality of education, administrative autonomy, and overall well-being of learners. The proposed amendments, if implemented without due consideration of the practical challenges faced by schools, could exacerbate existing issues and hinder the effective delivery of education. It is imperative that the concerns raised by Laerbur Alfeld and other stakeholders are taken seriously and that amendments are made to ensure that the interests of South African children remain paramount. We extend our sincere gratitude to the committee for the opportunity to present our concerns on the ballot. We acknowledge the importance of your role in shaping the future of education in South Africa, and we trust that you will carefully consider the points raised today. It is our fervent hope that decisions will be made in the best interest will be made in the best interest of the South African child, prioritizing their educational needs above all else. And I want to reiterate the African proverb, it takes a village to raise a child. Let us work together as a collective village to ensure the success and well-being of every South African child. Thank you, Chair.
Thank you very much, Dr. Skipper. All members, that's the presentation from Selborne Primary School, SGB. Life School. Life School, Alfeld, yeah. So Dr. Skipper, I marked the wrong one. Let me do it like this. Yeah. Are there questions of clarification questions to the present on the platform from the members? I don't see any hand from the system here. And Tate Skipper, thank you very much for making time to talk to us and talk to South Africans on this platform about what you believe is the right thing to do.
Thank you, Chair.
Going forward. Thank you very much. We'll call upon our next speaker will be Laerbur School General Albert's primary. They are represented by Ntate Martin Pretorius. Rep Pretorius, the floor is yours.
My apologies, Chair. I can't seem to find Mr. Pretorius on the platform. Can I suggest that we move to the next presenter in the meantime?
The next presenter this time will be Northcliff High School. Is it all right?
Yes, Chair.
All right. Northcliff High School SGB. They are represented by Ntate Bradley Lee. Ntate Lee, the floor is yours.
Thank you, Honourable Chair, and thank you to the honourable members of the committee for allowing us to make these oral presentations today. I really do appreciate, and I hope everybody is having a good Friday and looking forward to a good weekend ahead of everybody today. Thank you, Honourable Chair. If I may proceed, may I have permission to proceed with my presentation?
Yes, you are. You may continue.
Thank you, sir. I would like to start off by confirming that my name is Bradley Lee. I'm the chairperson of the governing body for Northcliff High School, and I'm going to be making oral submissions today regarding the proposed amendments to the South African Schools Act in terms of the Basic Education Law Amendment Bill. Written submissions were submitted to the chairperson of the committee in January 2024, and I'll just be adding some flesh to the bones of the submissions that have already been made. I'd like to first of all start off with the proposed changes that we are in support of, that we believe will enhance education. We would specifically like to refer to clause 2A, and this is regarding the requirement of compulsory education in grade R. We, as the governing body of the school, we do believe that it is to the benefit of education in the country and to our learners that grade R is made compulsory. However, I'd just like to echo the sentiments of the previous representatives that have made submissions to the committee regarding the costs and the flow on of the costs that are involved in order to move forward with allowing a grade R class. Obviously, the costing may not have a direct impact on Northcliff High School based on the fact that we are a high school and that grade R would be applicable to junior schools. However, the knock-on effect is obviously with the costs. We believe that the department is already severely hampered by the costs and obviously the budgets that they have. And we believe that including a further standard would further deplete the budgetary requirements of the department. And we believe that specific guidelines should be put in place in order to ensure that the budgetary requirements are met and that the knock-on effect to other schools is not substantial enough that it degrades the integrity of the education that's currently being presented to learners. However, I wish to reiterate that we do support the inclusion of grade R as a compulsory grade. We would just like the department to take recommendations regarding the budgetary requirements for the grade R project. Regarding clause 19, and this is the proposed amendment regarding uniform and national measures governing the election of members of governing bodies. The benefit regarding the effectual governing election of members, we are in support. And obviously we believe that this would further facilitate the actual collaboration between governing bodies and the department as is defined in terms of the Constitution. Regarding clause 38, and specifically regarding criminalizing the act of providing false information, we 100% support this proposed amendment. Our school has had numerous incidents of false information that has been presented, and unfortunately it adds a huge burden in order for the school to ascertain what is fraudulent and what is not. We believe that criminalizing the act of providing false information should assist in dissuading individuals from providing false information, and it will thereby alleviate the effect of the schools having to independently investigate and corroborate information that's been provided to them for the admission process. So I'd like to reiterate that the governing body of Northcliff High School would like to propose and support the inclusions of Clause 2A, Clause 19 and Clause 38. I'd like to now move on to the provisions that we have presented objections to as per our written objections that were previously submitted. And I'd like to start with Clause 4 regarding the admission policies of public schools. We do not support these proposed amendments. With reference to our previous comments, we strongly reiterate that we have serious reservations about the previous proposed amendments, as well as the current proposed amendments. The power to determine a school's admission policy vests in its governing body in terms of Section 5 of the Schools Act. Clause 4D of the bill proposes amending Section 5.5 of the SASA by introducing a provision which seeks to limit the governing body's power to determine the school's admission policy. The first substantive change is that the proposed Section 5.5A of the Schools Act states that the provincial head of department, after consultation with the governing body, has the final authority to admit learners to a public school. The referral to final authority, we believe, conflicts with the scheme of the Schools Act and applicable court judgments which envision a cooperative partnership between the governing body, the HOD, and the minister. The notion of a cooperative partnership between the minister, the provincial department, and the school governing bodies, as envisaged and prescribed in Section 41H of the Constitution, is undermined by giving the HOD this final authority. We have referenced Section 41H of the Constitution. I have no doubt that based on the stature of the members of the committee, they are well versed with the Constitution and specifically Section 41H. However, reference is specifically made in our written submissions. We believe that the proposal is firstly problematic for the same reasons stated above, and the requirement of the HOD's approval of the school's admission policy conflicts with the scheme of the Schools Act, which envisages a cooperative partnership between the governing body and the HOD. Secondly, provinces do not have the capacity to deal with ordinary day-to-day submissions and correspondence. With just under 24,000 public schools and with provinces struggling to deliver on existing legislative obligations, we have difficulty in seeing how they would be able to respond to all the submitted policies. At Northcliff High School, the school's admission process involves volumes of applications. Northcliff High processes approximately 1,949 applications for grade 8 alone. Of the 1,949 applications, there are availability for 280 placements in the school. In 2023, the Northcliff High School was engaged in litigation, and we were co-respondents with the Gauteng Department of Education. A learner had brought a matter to the courts based on the fact that they were not admitted into the school. And this was based on the fact that they did not fall within the criteria or the selection criteria for the school. On opposition, Northcliff High School and the GDE were successful in opposing that litigation, and the court decided that the learner did not have grounds for admission into Northcliff High. This was in 2023. The back end of that, in 2024, a learner presented admission to the school. And unfortunately, in that application, there was certain false information that was supporting the application. The individual or the learner was not in the feeder zone, had no siblings, and further, or no siblings in the school, and further, the parents were not working within the area of the feeder area for the school. So unfortunately, the application was not successful, and this was communicated to the learner and the learner's family. Family thereafter escalated the position to the office of the HOD or of the GDE, and it later, through discussion and consultation, it was the decision of the GDE that the learner should be placed in the school. Now, obviously, the contrasting issue that we have is on one year in 2023, we supported by the Gauteng Department of Education in opposing litigation regarding the admissions policy and criteria. The very next year, where a learner specifically does not comply with the admission policy and processes and further submits false and fraudulent information, is still forced upon the school to be placed by the Gauteng Department of Education. And this is one of the concerns that we have. I'd like to draw an analogy of the person who attends the HOD's office or to the department, and the person who has the biggest tantrum or throws the most amount of vigor towards their objection is generally the person that at the end gets placed. And this is the concern that we have with the HOD's office having an absolute discretion regarding placement. The concern is simply that the amendment may result in a floodgate of learners that are unhappy with not being placed, despite not complying with admission criteria. They'd be escalating the matters to the HOD's office that cannot accommodate the volume of disputes. The consultation process that will be required in terms of the amendment will place further and undue strain on the office of the HOD and the school. Further, on the instance of the HOD, schools would have to place learners despite their failure to comply with the admission criteria. The examples that I have just alluded to are proof thereof. As recently as last year, a letter was sent to some schools instructing them to increase their intake considerably. Possible court action was threatened by the schools, and a letter was later sent retracting the instruction to increase their intake. We believe that this situation may have been different if the HOD had sole discretion regarding the placements in the school. Believe that specific guidelines should be drawn in order to promote the involvement of the school, and strict adherence to placement criteria will enable the effective management of admissions to the schools and assist the placement of learners. These guidelines would effectively promote the spirit of Section 41H of the Constitution of South Africa. Firstly, guidelines should be defined before promulgation of the amendments in order to prevent the proverbial floodgate of referrals to the office of the HOD. 2, the guidelines would prevent unnecessary strain on the HOD's office and would place more emphasis on policy rather than on discretion. Thirdly, the guidelines would promote the involvement of the school and the principles as founded in the Constitution. And lastly, the guidelines would assist in effectively regulating and therefore effectively managing the placement of learners at what are already overcrowded schools. The effect of the discretion may, without specific policy and guideline adherence, result in the overcrowding of already overcrowded schools based on the ineffective management of referrals purely based on the volume thereof. Policy and guidelines effectively reduce and remove the effect of discretion. We reiterate that there is a great need for a set of objective criteria to guide the determination of schools' capacity, taking into account the minimum uniform norms and the standards for public schools. And we therefore reject Clause 4 of the bill and advocate for its complete removal. The next clause that I would like to discuss is Clause 16, and this is regarding the school's governing body's powers concerning procurement. Clause 16 seeks to empower the HOD to centrally procure identified learning and teaching support material for public schools after consultation with the governing body and based on efficient, effective, and economic utilization of public funds or uniform norms and standards, notwithstanding this function, may have already been allocated to the governing body under Section 21 of the Schools Act and without Section 22 applying. This proposed amendment is problematic, firstly, because it appears to provide a means for summarily circumventing the allocation of functions between the governing bodies and HODs for the purpose of procurement. This amendment seeks to enable the HOD to withdraw this function from the SGB without due process. Secondly, the implications of this amendment will be that the department will centrally procure LTSM for schools. Given certain provincial departments' incapability to deliver books to schools, there is a concern that the provincial departments will not have the capacity to deliver quality material on time. In practice, this amendment can be very problematic, and the proposed subsection, we believe, should be deleted. I'd like to reference the findings and recommendations as outlined in the Government Technical Advisory Centre's Lessons from Spending Reviews on Learning and Teaching Support Material, which was published in 2022. The following was put forward. Number one, although there is a national sector LTSM plan, this is not enough. There is a need for a clear national LTSM policy that provinces can adapt to their specific circumstances through the development of provincial LTSM policies. Thus, the recommendation is that the National Department of Basic Education should develop a national LTSM policy that guides the planning, procurement, distribution, and delivery of LTSM. The national policy should ensure that the LTSM program is implemented efficiently, delivers value for money, and that the provinces should customize the LTSM policy to their specific circumstances. Number two, several provinces have experienced vast challenges in identifying their LTSM needs accurately. Part of the problem is limited and unreliable data on textbook stock needed to determine LTSM needs across the provinces. Thus, the recommendation of the report is that the provinces should improve their processes and systems for identifying textbook needs. This includes strengthening the capturing and management of textbook inventory data. Provincial heads, offices, and National Department of Basic Education must also improve their monitoring capabilities. Procurement models differ across provinces and lead to varying levels of efficiencies and cost savings. Thus, the recommendation is that the Department of Basic Education must explore the possibility of developing a transversal contact with publishers for textbooks listed in the National Book Catalogue. Fourthly, there are questions about the integrity of LSRM data produced by SASAMS, BAS, and Logis. The lack of complete and reliable data makes data-driven planning and procurement extremely difficult. The recommendation is therefore that the Department of Basic Education and provinces must develop a strategy to improve the quality, reliability, and completeness of data on LTSM. Fifthly, provinces follow vastly different strategies for digitization and eLTSM. Currently, there is no coordination on the development of eLTSM, and the risk is that provinces might be duplicating efforts in terms of the content development, which comes at a cost to the fiscus. Thus, the recommendation is that the Department of Basic Education and provinces develop costed eLTSM plans. Lastly, the introduction of new textbooks require considerable additional investment by provinces over the 22 financial year. Unclear whether provinces have planned for this new development and it included in their projections. Thus, the recommendation is that the Department of Education and provinces must prepare a detailed costed implementation plan. Now, I wouldn't like to take the members through the numerous examples of service delivery failures by the department. We had 2018, the Department of Basic Education had an issue with delivery of Braille textbooks, which only occurred in November of 2018 after a High Court order. 2022, the Eastern Cape delivery issue with regards to textbooks that were only delivered to individuals in the Eastern Cape, belated in up until March. And in 2023 in Northwest, there was a further delivery issue, and there was actually a statement made by the CASAS chairperson, Bongani and Laerbur, where it confirms that it's shameful in a democratic country of South Africa for learners not to receive their stationery. We submit that allowing the government of LSTM and further services and ensuring their accountability may assist in what seems to be a prevalent issue of service delivery issues based on ineffective supply management. The final clause is clause 34 that we will be opposing, and this is regarding the providing of quarterly reports on all income. There was a research paper published by Simon Ditling Sebedi of the University of Pretoria, and in that it was determined that thematic data analysis was used to analyze collected data. All the participants in the program demonstrated limited knowledge and understanding of the processes and procedures of auditing financial records, including an inability to interpret audited financial reports. However, the participants revealed the benefits of audited financial reports, such as trust from parents in how school fees are managed. Furthermore, the audited financial reports enable schools to seek and apply for additional funding from businesses and other organizations to be allocated funds. Study recommends that the Department of Education should provide stakeholders in financial management with adequate support and training in auditing processes and procedures in the interpretation of financial auditing reports. Evident from the study is that schools have low level of knowledge regarding processes and procedures of auditing financial records. This further burden on schools' management structures to now submit reports on a quarterly basis may severely and adversely impair the ability of the school to properly account. We submit that until such time as the Department of Education provides schools with financial management officers with adequate support and training in auditing processes and procedures and interpretation of financial auditing reports, requiring the submission of quarterly reports would just burden schools' financial management systems, and the amendments would give effect to the requirement for further training and education. The quarterly reports in themselves are not an issue, except it could be very time-consuming drawing them up and ineffective for schools that do not have the knowledge as we have previously discussed. The department does not have the capacity to go through each and every report, therefore we don't see the need for it. As management of the school accounts to the governing body every month, the financials are prepared for by auditors and sent to the department once a year. The governing body are held responsible for these statements. The parent attends an AGM once a year where they can inspect both financial statements and the budget. The current situation allows for absolute accountability without any party feeling overburdened. Honourable Chair, these are the submissions that we have made. As I've said, it is an elaboration on the written submissions that were already submitted in January of 2024. I'd wish to thank the members, the honourable members of the committee and yourself, Honourable Chair, for allowing me this opportunity to present our submissions to you. And if there are any questions, obviously, I would be welcome to field those.
Chair?
Yeah, thank you. My phone had frozen. Yeah, that's the end of the presentation. Laerbur Lee. Are there points of clarity that members would like to ask to the presenter? I'll monitor that from the screen here. I don't see any hand. So, Dr. Lee, thank you very much for putting away time on the side so that you can come and talk to us and give your view and contribution towards the basic education laws amendment bill. Thank you very much. And we'll call the Independent Micro Schools Education First Research Group. They are represented by Mayor Yanin Texeira, and they will be followed by Section 27. Later, over to you, Mayor Yanin Texeira. If I'm pronouncing.
Good morning. Good morning, Chair. Thank you. There's been a change. I will be doing the presentation for Education First. My name is Jordan Willett. So, good morning, Chair, members of the Select Committee, and everybody here today. I'm Jordan Willett, representing the Education First Research Group. Today, I'm honoured to address you on a matter of great significance, the Basic Education Laws Amendment Bill. I'm going to share my screen so that you can follow along with me. All right, fantastic. So who is the Education First Research Group? Education First Research Group is a recently formed coalition of researchers, educators, owners of educational institutions, learners, and concerned citizens who have as a foundational principle that the right to education is a fundamental human right, and that right makes it possible to enjoy other human rights. And as such, education must be put first. We work closely with researchers, education, law, and policy associations, and the non-governmental sector, both locally and internationally. We'd like to specifically highlight the role of micro schools and how they fill the gap in the South African educational landscape and the changes that we hope to see in the Bellabor to accommodate and empower micro schools. Micro schools can be defined as an educational institution with 135 or fewer learners that operates outside traditional legal frameworks. These schools often cater to students with special educational needs or those who have not thrived in conventional settings, offering multi-grade environments and tailored learning approaches. What makes micro schools unique when compared to traditional mainstream schooling? Many micro schools are multi-grade environments where we see children of different ages and different academic levels sharing a space. Learning is tailored to the individual needs of the learner. And this can be done using alternative curricula or approaches, and even when the National Curriculum Statement or CAPS is used, they are adapted to meet the learner's needs. The National Senior Certificate is not exclusively used, and alternative school leaving qualifications are offered. The pupil to educator ratio is low, in a number of cases 10:1 or even smaller. A high percentage of these schools cater to learners with special education needs, but what we see is that even when learners do not have formally diagnosed special needs, a high percentage of learners have not thrived in the conventional school setting and have experienced barriers to learning when using NSC or CAPS-compliant curricula and related modalities. A number of learners who have struggled with mental health, bullying, and falling behind because of sickness, etc., are choosing to join independent micro schools to better suit their situation. Mastery-based learning is practiced in some environments, especially where learners have struggled with high-stakes summative assessments, such as end-of-year exams. Independent micro schools are often located nearby registered public and independent schools and work with them cooperating to accept and enroll learners whose needs cannot be accommodated in the larger environment of the public and independent schools. And the most obvious characteristics of these schools is that they are small, physical limited space, a small staff, and this makes it difficult to meet large school-based criteria when registering. The development and evolution of micro schools. The emergence of independent micro schools in South Africa was influenced by a misinterpretation on the policy of the registration of learners for home education. This misinterpretation led to the belief that an independent form of education, alternative to public or independent schools, was permissible. These micro schools evolved from homeschooling, with parents seeking alternative education options for their children and group socializing dynamics. The digital revolution, particularly high school broadband, accelerated the growth of the subsector, especially during and after the COVID-19 pandemic. Anecdotal evidence suggests that the independent micro schools grew very rapidly during and after COVID-19, as parents sought smaller, safer environments for their children or more personalized learning approaches to assist their children in catching up following the reopening of schools. A number of students then stayed in micro schools as it suited them better. The demand for small-scale, personalized education prompted the founding of numerous independent micro schools after 2010. Their rapid growth, especially in areas with insufficient school spaces, has made them a significant part of the education landscape. Despite the smaller size when compared to conventional schools, the number of independent micro schools may even rival that of independent schools. This growth has been acknowledged by the Department of Basic Education for years. However, the DBE has labeled these institutions as illegal independent educational institutions in 2018, even cautioning homeschoolers against associating with them. In Gauteng alone, nearly 70 independent micro schools have been shut down, possibly due to issues of legality or concerns about their quality. The closure of some of these schools may have been necessary, but the broader issue lies in the lack of a suitable regulatory framework leaving parents desperate for alternative education options without proper guidance or support. The state is criticized for failing to provide the necessary regulatory structure, ultimately impacting the best interests of both parents and learners. Nearly 80% of independent microschools would like to be able to register. However, the provincial registration requirements for independent schools have been designed with large conventional schools in mind. Registration is simply unaffordable. Some schools, a literal handful, have been able to register as independent schools, but the high cost of registration, including Umalusi fees, makes registration unattainable for the vast majority. The cost of registration for a micro school could amount to as much as 170,000 Rand, as in the registration cost for a conventional low-fee independent school. And this is beyond the affordability for these schools and micro schools that cannot meet the financial burden of registration in the way that conventional schools can. The cost of these registrations cannot realistically be absorbed by the small number of learners in such an institution. And while we do see that a number of micro schools' fees are more expensive than traditional public mainstream schools, most of these parents are also seeking additional therapies and support for their children and cannot fork out higher school fees in order to aid in the registration process. The situation is analogous to that of the registration of independent early childhood development centers. The DBE has recognized this and in the case of ECDs is assisting with registration drives. Responsible actors in the sector are actively seeking registration and have appeared before the PCBE during the oral submissions in Parliament to request an appropriate regulatory framework. The need to address the issue of independent microschools has been recognized in the final report of the PCBE on the Bellable and was mentioned in recent provincial hearings in Mpumalanga. Independent microschools are not just small schools. Many independent microschools use alternative curricular, educational approaches, and assessment processes and procedures that are simply not catered for in the current registration procedures. The lack of a legal framework exposes the learners, parents, owners, and both the DBE and the PEDS to a number of legal risks. The DBE has been aware of the existence of independent microschools for decades and specifically mentioned them in the 2018 Policy on Home Education, and has therefore had at least 5 years to close this gap. Recent coverage in the press has highlighted the existence of fly-by-night operators seeking to take financial advantage of parents and learners, and this is a consequence of the lack of a proper legal framework. This places learners, parents, owners, and even the national and provincial education departments in position of legal risk. In respect to the latter, for the failure to facilitate the right to basic education by creating appropriate legal frameworks. In light of what I've just mentioned, Education First is deeply concerned that Clause 33 of the Bellable, amending Section 46 of the South African Schools Act, proposes increasing the penalty for establishing and operating an unregistered independent school from 3 to 12 months. Despite the DBE being aware of the existence of IMS for decades and requesting submissions on both the Bellable and the Policy of Home Education for amendments of the law, the DBE has not engaged with independent microschools prior to the tabling of the Bellable in Parliament. The DBE has not taken any research into microschools, and this lack of research means that the socio-economic impact assessment is inadequate. Independent microschools are not mentioned in the SIA, and no comment is made on the increase on the penalty. No criminological research is presented on the advisability of this increase and the impact intended or unintended on both the parents, children, and organizations that facilitate this. So what does Education First propose? We make the following proposals: that specific provisions be added to the Bellable that instruct the MECs to issue instructions for the registration of independent microschools, that the right to use alternative curricular, educational approaches, and assessment processes and procedures is protected, that the best interests of learners are protected by including key principles of the Children's Act in Chapter 5 of the South African Schools Act, that the increase in the penalty to 12 months be removed from the bill, and that unregistered independent institutions are included in dispute resolution processes. These proposals are reflected in the clause-by-clause section of our written independent microschool submission that was presented earlier this year. In addition, we request that the Select Committee take the following under consideration: that microschools receive a full rebate on Umalusi fees, that duplications between the provisional registration process of the PEDS and Umulusi should be eliminated, that microschools are invited to present to the Select Committee wide of the Education Bill of the Bella Bill process, that special note be taken of the role that microschools play in providing education to learners with special needs and those who struggle in the CAPS environment, that research be conducted into how independent microschools can assist on a national level in addressing the special needs crisis, and that microschools are included in the representative structures established by the Minister of Basic Education at a national level and the MECs in their respective provinces. Education First Research Group has made suggestions on clause-by-clause amendments, but the ones that I would like to highlight are the detailed proposed amendments included in the IMS submission, with an emphasis on definitions to include independent microschools, alternative curricula, and modalities, that there will be a protection of autonomy with regards to assessment and curricula used by independent microschools, that the admission age criteria be considered in necessary instances, efforts in registration, the penalty of clause 33, that subsidies be provided to independent microschools, and that when school closures are instituted, that the best interests of learners are taken into consideration. In conclusion, independent microschools play a vital role in our education, and their challenges demand urgent attention. Education First's proposal provides a constructive pathway for regulatory reform, securing a balanced and equitable education system. We urge the Select Committee to adopt these proposals promptly. Thank you for your time and attention today. I'm confident that our collaborative efforts can pave the way for positive legislative reform, ensuring the sustainable operation and protection of the interests of learners and educators in independent microschools. We look forward to continuing conversations as active stakeholders. Thank you.
Thank you very much. Honourable members, that's the presentation from Independent Micro Schools Education First Research Group. Thank you very much. Are you done?
Yes, thank you so much, Chair.
Okay, thanks, a million. All members, are there points of questions, clarity-seeking questions to the presenter? Monitoring it from here. No, there are no clarity-seeking questions for now. Thank you very much for your presentation. The committee will hold a meeting after this, and then we will engage. And those meetings will be always in the public domain. So those who have made their presentations can actually follow this on coming meetings on YouTube and parliamentary channels. Thank you very much. Well, members, there being no questions, I'll call upon the next presenter, who will be section 27. They are represented by Mayor Michelle Petherbridge, if I'm pronouncing your surname well.
Yes, thank you very much, Chair.
Over to you, ma'am.
Thank you very much. Good morning, Chair. Good morning, honourable members of the committee and fellow speakers. My name is Michelle Petherbridge. I'm presenting on behalf of Section 27 this morning, and I'm going to just quickly share my screen. There we go. All right, so just to describe a little bit about who we are, Section 27 is a public interest law organisation based in Braamfontein, Johannesburg, and we use the law in a variety of ways to further the right to basic education and the right to access to healthcare in particular across South Africa, and we do this through a number of ways, such as research, advocacy, and litigation. In terms of our submissions, we're going to address 13 issues. I note that the committee has our PowerPoint presentation already, so I'm going to jump right into them. In terms of compulsory schooling, Section 27 welcomes the introduction of compulsory grade R. However, we know that learners who are enrolled in this compulsory grade R need to be provided with quality education, and what this will require is appropriate and equitable resourcing, learning support, and qualified teachers who can implement play-based learning programs. So in order to facilitate this, the kind of recommendations we're making into BELA is that BELA amends Section 5A, subsection 2C of the South African Schools Act, and that is the section that concerns the minister's power to publish norms and standards, particularly on learning and teaching support material. And what we want is to see the inclusion of a reference to the availability of age-appropriate play material and equipment. In addition to this, we also welcome the DBE's recognition that basic education extends to grade 12 and is no longer limited to just grade 9 or learners who are the age of 15 years. And this is in line with recent Constitutional Court judgment, and in particular the Moko versus Acting Principal of Malusi Secondary School and others case. In respect of corporal punishment, we welcome the inclusion of a definition of corporal punishment, and particularly the confirmation again that it's abolished in schools. But we believe that the abolishment of corporal punishment should not just be limited to those physical forms of corporal punishment. They need to also be extended to non-physical forms of corporal punishment. And so we are recommending an inclusion in Clause 10 to be revised to include the abolishment of any form of punishment that is cruel and degrading. And that this be clarified in Clause 1 in particular, which should now be amended to include punishment which belittles, humiliates, denigrates, scapegoats, threatens, scares, or ridicules the child. And through these amendments, we believe that those non-physical forms of corporal punishment, which would include things like name-calling and threatening of learners, will now be included in the BELA bill as well. In terms of learner dropouts, we believe that it's not effective to make individual schools, and particularly principals, educators, and school governing bodies, solely responsible for tracking and tracing learners who are absent from school and to provide interventions for them. We feel this needs to be a collective effort with all stakeholders, and what we are recommending to facilitate this is that Clause 3 of BELA be revised to include a provision that will oblige government to form intergovernmental committees at both a provincial and a national level. And our suggestion or proposal is that these committees consist of representatives from the DBE, the Department of Social Development, the officials from Stats SA, and National Treasury. In terms of the admission of undocumented learners, what we have noted in the BELA bill is that most of the documentation that is required to be provided in terms of Clause 1 when admitting a child into school is not in line with what the courts have said. We know that Clause 4, subsection B of BELA says that even without this documentation, a learner will still be able to attend school. But we note that BELA still obliges a principal to tell parents or guardians to obtain these documents. And this goes against a decision that was made in 2019, and in particular the Centre for Child Law versus Minister of Basic Education, that said that all learners need to provide is their birth certificates. And where this is not available, any other proof of identity, like an affidavit, that needs to be admitted to school. So what we are recommending is that Clause 4 of BELA be altered to only provide that learners need to provide a birth certificate. And where this is not available, any alternative form of identification is allowed. And that would be an affidavit, a sworn statement by a parent, a caregiver, or a guardian, or a document when the learner is fully identified. In terms of policy-making functions of school governing bodies, what we have seen through our advice desk is that there are SGB policies that have excluded learners, and we know these have the potential to continue such an exclusion and perpetuate historical discrimination. And that is why we welcome the fact that school policies can now be reviewed by the head of department, and that the BELA bill makes a possibility for this in terms of clauses 4 and 5 of BELA. What we are worried about is that there's now been an omission of certain steps in terms of due process. And in particular, we note that there's a deletion of the head of department's obligation to actually provide reasons and substantiate why it does not approve a policy. And we see this was something that was present in the previous BELA bill. Why this is so important for us is that written reasons ensure that there's a higher level of transparency. In the event that a head of department's decision is appealed and sent to the MEC without reasons, this decision is not properly substantiated. Without reasons, that decision-making is also inconsistent with principles of administrative justice. What we've also noted is that in the event a head of department doesn't approve a school governing body's language or admission policy, and an SGB doesn't take steps to appeal that, there is no process defined for what needs to happen next. The previous Bella Bill did include steps such as the HOD returning it to an SGB with recommendations or amendments that needed to be made, and this has now been excluded. So what we are recommending is that there be clarity now in terms of a process that must be followed if a head of department does not approve a school's admission policy or language policy. And if they're not satisfied, they also need to be obliged to provide reasons for this decision. In addition to this, we need to make sure that the head of department actually has the capacity to review all these policies effectively and within the timeframes that Bella is now proposing. And what we're recommending is that an office be established that will actually specialize in reviewing these policies and to undertake the initial review of SGB's language and admission policies within the 30 days of commencement of Bella. We also recommend that an individual complaints mechanism be established for persons who want to challenge individual school policies outside of this HOD process and outside of the review periods specified in Bella. We note that all schools of conduct need to have exemption clauses. And in terms of this, we believe that Clause 7 of Bella needs to guide school governing bodies a bit more in what exactly the meaning of just cause is when granting or refusing an application for an exemption. What we are recommending is that there be suggested factors included in Bella that could include the best interests of the child or the ability of the school to reasonably accommodate a learner. This will make sure that SGBs are considering relevant factors when making this decision and are aware that they have a duty to reasonably accommodate learners. In addition to this, what we have seen through our advice desk is that there are still ongoing exclusions of learners who are pregnant. And what we would like to see in the Bella Bill is a clear and express provision stating that any direct or indirect discrimination against learners who are pregnant is completely prohibited. In terms of school governance checks and balances, we recognize that there are times when a head of department would want to dissolve a school governing body, and we see this presented in Clause 21 of Bella. However, we recommend that there be greater clarity on the grounds upon which an HOD may rely when they take the steps to do this. We also note that SGBs are not often trained in how they're supposed to perform their functions, and we note that there need to be greater and effective programs run by the state to capacitate our SGBs, to give them information on their roles and how to address power imbalances between staff and SGBs. In respect of school closures and mergers, we submit that Clause 13 of Bella needs to be revised so that there's an obligation placed on the MEC when deciding to merge one school with another to take certain things into consideration. And we've inserted this because we see this constantly coming in through our advice desk, that there are issues that are often not resolved before a merger takes place. And so what we want to see is an obligation on the MEC to make sure that there is adequate school infrastructure provided to accommodate all learners in their new school, that there is adequate and sufficient transportation to make sure all learners can get to school, and that any challenges involving school uniforms be addressed before a merger commences. We also note that this version of the Bella Bill has taken out a step like we saw previously in due process. And what we want to see is that when an MEC makes a decision to merge a school, that they provide reasons why that decision has been made. As I mentioned, it wasn't the previous Bella Bill, it's now been taken out. And as I mentioned before, this will really ensure transparency and greater accountability, and we'd like to see this included again. In terms of dispute resolution, Clause 37 of Bella seeks to introduce those steps that must be taken when trying to resolve a dispute between heads of departments or MECs and school governing bodies. But we see that this clause doesn't really guide these parties very much on how to resolve these disputes, and in particular, there's no criteria on how these parties can go about this. And we see that there's a failure to refer to any kind of meaningful engagement as a way to resolve these disputes. What we recommend and think will facilitate this is that normative criteria be included in BELA to guide the resolution of disputes that will promote meaningful engagement. And this criteria can include, for example, fairness, transparency, flexibility, practicality, as well as the best interests of the child principle. In relation to the centralized procurement of LTSM, we see that clause 14 of BELA allows for this on a provincial level. But we also note, and this was particularly highlighted in a recent case, Cooler Development Project versus Head of Department, Eastern Cape Department of Education, that the centralization of this procurement does not necessarily solve all the problems related to this. What we recommend is that the department urgently finalize norms and standards on the procurement of LTSM in terms of its powers in section 5A, subsection 1, subsection C of SASSA. But we also recommend that clause 14 of BELA be amended to make sure that any kind of procurement of LTSM that takes place is also in line with the principles of good governance set out in section 195 of the Constitution. In relation to the criminalization of parents who failed to cause their children to attend school, section 27 notes that this is ineffective. It's against the best interests of the child, and it has the potential to disproportionately prejudice mothers in particular. We recommend that these kind of criminal sanctions on parents be completely removed from the BELA bill. However, in the event that they are kept, we note that these have to be made subject to certain considerations to make sure that the best interests of the child are protected. In relation to the penalization of persons and protests that obstruct or disrupt schooling, we know that there is a need to prevent protest action that is disruptive, that will infringe upon persons' rights to basic education, and that they should be penalized for this. But we submit that the creation of a new penalty for this in clause 2 of BELA is too broad, and it runs the risk of violating a range of constitutional rights. We know that there is a host of existing law that penalizes persons participating in protests already, and we feel that there should just be greater enforcement of these laws and that this amendment be removed entirely. In relation to random searches of learners, we feel that schools need to be guided further than what is set out in Section 8A of SASSA on how to undertake these random searches. We submit that the minister should be granted the power to make regulations on searches and that she should take steps to publish this as soon as possible. But we also recommend that rules relating to searches of learners should be provided in every school's code of conduct. In relation to alcohol on school premises, Section 27 is of the opinion that the most effective way to protect our learners is to make sure that there is a complete blanket ban on the presence of alcohol on school grounds during school activities, except for those instances where it's for educational purposes. What we're therefore recommending is that clause 8 of BELA be revised to insert alcohol into the list of banned substances that are prohibited on school premises. Of course, again, noting the disclaimer that unless this is for the use for educational use. And then lastly, we note that clause 40 of BELA proposes to make changes to the preamble of SASSA. However, we recommend that that clause 40 be rephrased to encompass the full extent of obligations that is imposed on the state by the Constitution. And in terms of this, we're recommending that clause 40 be amended to state that South Africa's new national system for schools will facilitate the education of children through respecting, protecting, promoting, and fulfilling the right to basic education. And this will be in line with those duties that are imposed in terms of Section 7.2 of the Constitution. So that is our full presentation. I thank you very much, Chair, and the committee for the opportunity to make this. And of course, there are our details in the event of any questions. Thank you very much, Chair.
My apologies. I think we've lost Chair. Can I kindly request one of the honorable members to take over in the meantime?
Hi, Nolitando. Who is next? Is there another presenter that's on next?
Next online is Learning Cat Remedial Teaching, and the presenter is Ms. Catherine Kenyon.
Thank you. Can Ms. Kenyon please continue with the presentation?
Hi, thank you very much. Thank you to the chair in his absence, to the other members of the committee. May I please share my screen?
Yes, please.
Okay, so I am an owner of a micro school, and I'm also actually part of one of the people who does participate in the Education First research group that was mentioned earlier. So my name is Kath Kenyon. I run a very, very tiny school. I literally only have space for 4 physical attending learners. And then I actually have other learners who are doing remote learning from around the country. And my micro school actually sprang up organically because my very first student was paid for by the state. He was on roll at a state-funded special school, and it was deemed that he was too volatile and too dangerous to have on the premises. And they paid me to teach him off-site in a different space. And since then, I've actually been given students by the department that via them or other experts have been deemed ineducable. So what I do is I run an alternative curriculum. It's not currently listed as an approved curriculum in South Africa because any attempts I've made to do so have been met with blank stares and the answer of, we'll get back to you. It's a recognized curriculum in the UK run by an NPO called ASDAN. They have options for children with disabilities ranging from very, very low functioning, literally as long as they can communicate in some way, all the way through to the equivalent of GCSE and A-level courses in the UK, which operate at about NQF levels 3 and 4 in South Africa. And as I've said, I cannot seem to get these lined up in South Africa at all. I just keep getting given blank stares. They offer courses in things like there's an international awards program, which runs at bronze, silver, and gold, which equates to GCSEs. There's key steps for slightly younger children between 12 and 14. Most of their courses are actually geared for kids between 11 and 25, although there isn't technically an upper age limit. The Towards Independence and the New Horizons courses you can see here are for very low functioning children, and they focus on teaching independent living and, as far as possible, employability skills. The short courses are again equivalent to a GCSE on the UK system, and as you can see from my list, they are very comprehensive. There are many that are not on my list that I do offer. There's a manufacturing one, there's a hair and beauty one. That they are very basic introductions, but if they can be recognized by CETAs here, these students could actually use them to find work. I have had students who've gone on from doing animal care and the environment and land-based, they've gone on to find work, which they would normally be denied because the normal traditional South African exit routes are denied to them because they can't pass grade 9 using a conventional method. So as I said, my success stories, my students are finding jobs. My school has grown from 4 in-person students to 30 remote and hybrid students. I have students as far away as the UK and Germany. In the last 3 years alone, I've issued over 100 certificates because students can work at their own pace, and it's all about mastery. As I've said, students who've been branded as ineducable are actually achieving things. I've got students working at their own pace. All certificates are recognized in the UK, and so far I've had 100% of success rate. The things that my program offers is the ability to work at their own pace and individualize the curriculum. They are being taught employability skills, they're being taught independent living skills, and they're being taught in a way that gives them dignity. Some of the reasons that parents have come to find alternative education such as mine: lack of space. We've heard this before. There are thousands of grade 1s and grade 8s that just have not been placed yet. And in the disability sector, it's even greater. The waiting lists at state special schools are miles long. There are children who are on those waiting lists for years before they get offered places. Then there are children who are being bullied at school, or they are just struggling with anxiety. They cannot function in a traditional school system that is as big as our schools are. They just can't cope. There are lack of accommodations. Too often, children's special needs are actually being pushed out of the system. The number of students who've come to me and their parents are telling me how they have been told by Department of Education representatives, don't waste your money finding a school, your child is ineducable. Or they are being put in schools that don't know what they're doing with those disabilities. They're not trained. I have students coming to me from a school with children with specifically with physical disabilities. And those children are being told, well, the parents are being told, take your child out, because for that child to use their specialist equipment means that they're losing out on teaching time and that we can't accommodate them. This is a school designed for children like that, saying that that child cannot be met there, their needs cannot be met there. And then with things like the fact that so many of our grade 4 learners can't read for meaning, so many of our grade 6 teachers can't do grade 6 maths, there is just a general loss of faith in the state system. These are 4 of the key reasons why parents are seeking alternative education and why we actually need to be recognized and accepted. So there are several versions of modes of alternative education. There's homeschooling, which we've heard about before. That's education in the child's own home. There's online schooling, which definitely sprang up big time after COVID. So obviously learning through a digital platform, and that can be at home or at a tutor center or at a cottage school, micro school. So independent micro schools are also called cottage schools. They're very small, often less than 70 students, definitely less than 135. As I said, in my case, depending on how you count, anything from 4 to 30. Tutor centers, which are often running after schools programs and short-term tutor spots where a child might come in only for an hour or 2. And then there's a hybrid of all of the above. My center is definitely a hybrid. I currently have 2 students who actually come in 1 day a week. Everybody else works online. And where this is really useful for children with disabilities, children on the autistic spectrum now have safe spaces where there is far less stimulation, there's far less sensory overload, their needs can be accommodated. Low functioning and low IQ students can actually now find a curriculum that works for them in a space that works for them. I've heard stories from a representative, the Deputy Chief Director of the Human Rights Commission for the Western Cape, shared a horrific story of a special school in Mossel Bay where all it was providing was a concrete floor for the resident or the students to sit on all day. No stimulus, no interaction, nothing. This is where independent micro schools can help fill those gaps. Working with children with dyslexia, they can be given support more easily in a smaller environment. And I've mentioned physically disabled children, medical issues. If you've got something like cerebral palsy, chances are there's comorbidities that go with that. If you've got a child with leukemia, they're going to need regular medical appointments. Micro schools can actually facilitate all of those appointments because we're not constrained by having to keep up with bigger classes, bigger groups, and a strict curriculum. Last week, I attended a focus group on this with the Department for Women, Young People, and Persons with Disabilities. And the biggest take back from that was the support I received for the concept of independent micro schools and alternative education in providing the constitutional right of a good quality education to children with disabilities. And you can see, I actually heard directly from Dr. Pravina Sukra-Eli about this, and she is very, very pro allowing micro schools and other alternative education modes to help with disabilities and ensuring their constitutional rights. So basically, independent micro schools are filling a very important gap. We are picking up children who have not been placed in schools, either permanently or temporarily. We are providing children where current provision doesn't meet their needs. We are allowing for hybrid and remote learning, which are 21st century approaches to schooling. We need to change our mindset to get out of the Victorian mode of schooling that is so often what our classrooms currently look like. We need to be able to give small spaces to the rural schools where schools are being closed because they don't meet the 135 student limit. Micro schools can spring up in those areas and can help. We have a really important role. Part of now, I know the government has brought in the DCAPS curriculum for disabilities, but it's still very much based on CAPS. It's still assessment driven. It's not flexible. It's very prescriptive. And a lot of the content is actually not empowering the learners or teaching them any employability skills. And certainly when I've had a student who's been taken on to a state-funded special school that they run DCAPS, And the proviso that they took that student was that he continued on roll with me and continued my courses outside of hours to prevent him regressing, because that's what decaps would result in. Need I say more? Now, the problem is Clause 33 makes my school illegal. The constitutional national law says I must register, and Clause 33 says I can go to jail for a year if I don't. And according to Oxley, I'm a fraud teaching fraudulently. But I cannot register because the Western Cape law says that I need to note that special needs schools under 10 cannot register. They cannot confirm if this applies to students over 15, online students, remote learning students, or part-time students. The vast majority of my students fall under one or more of those points. I'm an illegal, unregistered, and exposed because of all of this. My billable journey, I have been part of trying to get responses from the department and the government since 2017, which is more than 5 years ago. I submitted my original proposal in the first round of submissions. I've had no response. In 2022, I again submitted my views, and I was then invited to present to the Parliamentary Portfolio Committee. And again, I received positive responses from the members of that committee. And I was heard and promised responses from the DBE that I'm still waiting for. There's been no consultation with IMS on our roles and how we can play our role in helping the Department of Education provide education to children, particularly with disabilities. We are only ever met with threats of penalties. We are never engaged in anything, and no research has been done into what we're doing. So the available does not currently include independent micro schools, online schools, hybrid schools, tutor centers, or learning cooperatives, which is often made up of homeschool families working together to pool the adults in the scenario's best skills. Many IMSs cannot register because of the inflexible criteria. I've already demonstrated why I'm having a problem. We therefore are excluded from funding applications, which then makes us elitist. I would love to be able to run my program with children from poorer communities, but I have to pay pounds to register my curriculum. And if I cannot get funding from the private or state sector, I cannot reach the children I would love to reach the most. And it also results in the fear of being shut down, which means that there are many micro schools that fly completely under the radar. Some of those are absolutely fantastic. Some of those are diabolical because the lack of legislation allows them to fly under the radar. We need to have suitable legislation that includes us so that we can actually be legitimate, we can be held accountable, and we can fill in the gaps that traditional education formats don't do. So what we want specific provision to instruct the MECs to issue instructions for the registration of independent micro schools. We want the right to use alternative curriculum options, particularly with children with disabilities or special needs, because this meets their needs and allows for them to reach their goal of actually receiving a decent education. We'd like the best interests of the learners being protected by including the key principles of the Children's Act in Chapter 5 of the South African Schools Act. We'd like unregistered independent institutions included in dispute resolution processes, because many of us would like to be registered but currently can't. The increase in penalty to 12 months needs to be removed from the bill so that those of us who are filling the gaps and are providing quality service can continue to do so without the fear of being penalized for doing so. The IMS proposal offers specific clause-by-clause formulations, which my colleague Jordan Willett actually did speak about, and the proposal was attached to my initial submission as well. And we also request that micro schools receive a full rebate on Umalusi fees. Again, this is what Jordan touched on earlier. That we are invited to present to the select committee wider this process. That the special role that we provide is being taken into account, particularly with children who cannot access CAPS or similar state curriculums because of their special needs. That duplication between the provisional registration process of the provincial education departments and Umalusi can be eliminated, thus helping us reduce costs. And also that micro schools are included in the representational structure established by the Minister of Basic Education at national level and the MECs in their respective provinces. I'd also like to ask a personal favor. Could somebody please ask the chair of Umalusi to contact me when they present their budget so I can get my students' courses aligned and recognized? These are very valid courses. They are internationally recognized. The organization runs courses all over the globe, as you have seen. And it would be nice to know that people in South Africa can be using those certificates legitimately. Finally, I invite the select committee to visit my independent micro school, where you can actually see how children with complex disabilities who have been branded ineducable by everybody else thrive and do incredibly well. Thank you, Chair, committee, and everybody else, and I hope that, and I'm happy to answer any questions.
Thank you very much for this moving presentation. Honourable members, that's the presentation from Learning Cat Remedial Teaching, May Catherine Kenyon. Are there questions of clarity, seeking questions from members? Checking from my screen, I don't see any hand here. So in the absence of any hand from the members, let me thank you, Catherine Kenyon, for availing your time to share this important information with us. Thank you very much. We will move on to Learn Free, which is represented by Dade Christopher Cordeiro. Cordeiro, the floor is yours. The microphone is yours.
Thank you, Chair. I just want to confirm that everyone can see the presentation.
Yes, sir.
Thank you.
Yes. Yeah.
Honourable Chair, members of the committee, of the Select Committee, fellow presenters and members of the public, it is an honour to make the submission on the Bella Bill. Learn Free has a very simple mission and focus, doing all we can to make education available to as many as possible for as low a cost as possible, and wherever possible. Our core value is that this is best done by promoting freedom in and of education. Freedom of education relates to the freedom to establish education institutions outside the public schooling system, and freedom in education seeks to maximize freedom within the public schooling system. Learn Free works closely with researchers, educational law and policy associations and the non-governmental sector, both locally and internationally, to enhance educational freedom. Two key values that inform our work are subsidiarity and solidarity, or Ubuntu, both key constitutional principles in South Africa. The principle of subsidiarity requires that authority be exercised at the most appropriate level. This does not always mean at the lowest level possible, as is sometimes thought. For subsidiarity not to become the societal equivalent of pull up the ladder, Jack, I'm okay, it needs to be in a dynamic equilibrium with the principle of solidarity. This principle is recognized at one of the deepest levels by the concept of Ubuntu, that it is only by recognizing your humanity and rights that I realize my own right and humanity. A concern, therefore, that everyone has ladders, and a fundamental requirement for peace and societal development. Today, I will provide a brief root cause analysis of the problems in Bella Bill and explain why, based on our goals and principles, we have to unfortunately reject the Bella Bill in its current form and request that substantial changes be made to the bill. It is our request that the Select Committee takes leadership and makes the amendments to the bill in line with our submissions, and then sends the bill back to the National Assembly. We believe that this will not delay the bill greatly, and that with the support of NGOs and civil society, the amendments we propose could be included in the bill. Bella Bill is the first major reform of the education system since the 1996 SASSA was drafted. And SASSA addressed the major administrative task of creating one education system out of 17 racially divided departments. But unfortunately, which was of course a highly successful endeavor, but unfortunately, sometimes success breeds its own problems. And a successful transition can be built on an idea, can build an idea in the memory and culture of an institution that problems are best solved through complex administrative processes. That is, of course, not to say that there's no value to administrative solutions. And there are places where the Bella Bill provides sensible administrative provisions. An example is Clause 35, proposing that Section 51.6 proposing section 51.6 that allows for a form of deemed registration if a homeschool application is not processed within 60 days. Clause 37, creating a dispute resolution mechanism, is a step in the right direction towards stronger process rights. Although, as was made clear in the South African Institute of Race Relations submission, this should not infringe on the right to access to the courts. Clause 6 that allows for the appointment of persons or groups of persons to advise the minister on curriculum is also welcomed, especially if the minister uses this to reach out to experts in the emerging educational modalities such as homeschooling, collaborative homeschooling, independent microschooling, distance education provision, and online and hybrid schooling. These are sectors that are, these are modalities that are at the forefront of experimenting with curricula and the approaches of the future of education. However, a key question is, does the Bella Bill provide a foundation to meet the looming education crisis that we will face in the next decade? We know that in the next decade, over 50% of our educators will retire. We also know that, that meeting the Millennium Development Goals, which set a bold goal of increasing access to basic education, and a goal that South Africa can actually proudly say that we achieved, however, came at the cost of quality, with classes becoming overcrowded. And this is by no means only a South African experience. Population shifts in South Africa create serious resource a resource allocation crisis. Schools are built in rural areas with libraries, laboratories, and school fields, and then just when they have opened, they empty out of learners who then move to urban areas, especially to the Gauteng and the Cape Town metropole. Ms. Kath Kenyon spoke eloquently about the special needs crisis, so I'm not going to speak about that, but there is this significant special needs crisis that we face. Finally, we have the budget crisis. Of the post-apartheid education system in South Africa. One portrays it as an unmitigated disaster, the other as a major success. Those who see it as a success point out to the undeniable increase in access to education, the increase in bachelor passes, etc. Those who see it as a failure often look at whether this has been achieved in a cost-effective fashion. There can therefore be little doubt that there has been significant successes, but at a substantial cost. It is clear that an inflection point was reached several years ago, and we cannot expect ever increasing budget allocations. The critical question that we face now is how to achieve ongoing successes, but within the budget that we have. Unfortunately, when we look at Bellable, what we see is an administrative bill that wants to give the education system a tune-up, but that will not present a solution. There are key problems with the bill. These are essentially what is in the bill, and areas that we will focus on are lowering the compulsory education age, SGB powers, penalties for non-school attendance, closure of micro schools, impacts on independent education, both the penalties for unregistered schools and the impact on homeschooling. There are then things that are not in the bill, and these are, sorry, I'm going to just go past that slide. There are then impacts that are not in the bill, and what is not in the bill is ECD, learners with special education needs, sufficient attention to that, independent micro schools, online and hybrid education. There is a lack of concern for procedural rights, and more broadly, we need to look at a substantial law reform. I will deal with all of these in turn. There is no research on how many ECDs offer grade R that are not registered, and these unregistered ECDs could face prosecution and an increased penalty in clause 33 when the provision on lowering of the compulsory school age comes into effect. The lowering of the compulsory school age also has an unintended impact on homeschooling, because what will happen is parents who do not want to put their children into ECDs will then be required to put their children in, will then be required to register their children for homeschooling. And we know that despite heroic efforts of staff in some of the provinces, the existing number of homeschooling applications has led to significant backlogs. And in fact, in some PEDs, it almost seems that they've given up processing homeschooling applications at all. So the question would be, once you lower the compulsory schooling age, how will you deal with the influx of applications for homeschooling? All in all, what unfortunately is missing in the bill is a comprehensive ECD section. The draft bailable excludes the broader ECD phase for 3 to 5 year olds, and the and this is notable because the PCBE actually agreed to include ECD in the bailable, but this was not actioned. While the second care bill, the Children's Amendment Bill, the second care bill 2023, is planned to address ECD, the question is, why is the compulsory requirement included in the bailable now, but no legislative framework including how to achieve it? Would it not be better to rather incorporate the compulsory education requirement and the whole of ECD in a new comprehensive ECD bill? Another area of particular concern, and this has been raised by a number of other groups, such as the Equal Education Law Centre and Equal Education, is the increasing penalties for non-school attendance. This is an anti-progressive move. Research shows that it will have the opposite effect. Until 2013, fines of $250 could be compounded by court fees of up to $1,000 in Los Angeles for truancy. This led to a crushing debt for poor families, and the fines actually increased truancy from 5% to 28%. This is stated in UNESCO's 2017-2018 Global Monitoring Report on Accountability in Education. And that report is readily available, but does not appear in the SEER. The SEER, therefore, is incomplete. The socioeconomic impact assessment is therefore incomplete. It is proposed, therefore, that this section is removed, and that truancy should be directed to the Children's Court. There is also clearly, from all of the inputs that we've seen over the last 3 days, a fundamental crisis in SGBs. But unfortunately, the concern over admission criteria and language policy are hiding the need for urgent, more comprehensive reform. The Equal Education Law Centre and Equal Education described how two conflicting motivations led to the creation of a world-leading cooperative model of school governance. And our SGB model was and is a leading example of stakeholder involvement in education. However, this model has not been enhanced and developed in the last 30 years. This has made it vulnerable to unwarranted state intervention. And a false dichotomy exists here, that there are no options other than increased autonomy for SGBs or increased executive control. We propose a dialogue process that emphasizes a third way based on process rights and true subsidiarity and solidarity. In the interim, we would support the proposal made by Solidariteit. This is by no means a complete solution, but it may offer a solution for some schools that was made before the PCBE, that a clause be added to the bailable that allows for public schools to be converted to independent schools. This should proceed under suitable conditions, of course. An area of particular concern for Learn Free is the closure of small schools. The closure of small schools, particularly in rural areas, is an effective death sentence for rural communities. Bailable's proposed Section 34, Clause 35, that allows primary schools with 135 learners or less and high schools with 200 learners or less to be closed down without reasons needing to be given, is fundamentally unconstitutional. There is an engagement process here, but critically, no reasons for closure need to be given, as is the case with larger schools. Simply, again, this is unconstitutional and a violation of one of the key principles of our Constitution. Section 33 of the Constitution entrenches the right to fair administrative action that is lawful, reasonable, and procedurally fair. And it's notable that this was one of the, this was one of the key concerns with administration under the apartheid regime. So the desire to close microschools, predominantly in rural areas, is part of the resource allocation crisis that we face. I spoke about that earlier. These schools are financially unviable and struggle to deliver quality teaching and learning. That cannot be doubted. But once again, there are hidden assumptions here. The fact is that it is difficult to deliver the highly prescriptive and lockstep National Curriculum Statement, or CAPS, in a multi-grade environment. But the solution is not to close those schools, but to find curricula and approaches like those used in homeschooling and independent microschooling that are precisely suited to multi-grade teaching and learning that do deliver high-quality education. And this is a prime example of how freedom in education, not necessarily freedom of education, can save schools. The Western Cape has placed a moratorium on the closure of schools because of the inadequate, and I would rather say no research, on the impact of rural school closure and the reliance of that process or policy on exclusively financial models. Once again, there is not only no research on this topic in the SEER, there is simply no mention of it in the SEER. It was argued before the PCBE that this fundamental right to reasons could not be violated, and that the Promotion of Administrative Justice Act would in any event protect small schools. It is no doubt that that's true, but the schools would have it is no doubt that that's true, and that the schools would have the right to reasons being given. But why is there mention? But what should we say? Why then is there no purpose? But it does appear that then there's no purpose that large and micro schools are being treated differently, and we should not have Section 33(4) at all. We urge that the committee simply remove it. The impact of Clause 33 on independent micro schools has been comprehensively covered by the Education First Research Group submission and by Ms. Kath Kenny. And Learn Free endorses their oral and written submissions, and I will only make one point. The state's duty to ensure children receive basic education is not only one.
Kodero, your time is up.
I've only got.
I'll give you an extra minute just to round up.
I've only got 15 minutes on my clock, Chair. And I was told 30.
Yeah, I'm monitoring the time. Continue.
Thank you, Chair. The state's duty to ensure children receive basic education is not only one of providing education, but equally one of facilitating education by private providers, and the state fails in this duty to facilitate. Learn Free's position is that Clause 51 on home education should not be included in SASSA, but in a separate education bill. Ms. Mariki Uckerman has made a compelling case. Ms. Mariki Uckerman has made a compelling case for setting out why homeschooling should not be in the South African Schools Act. Not only does the inclusion of homeschooling negatively impact the unique nature of homeschooling, but the inclusion of homeschooling also impacts a number of definitions in the Act itself that negatively impacts public and independent schooling. We believe that home education should be regulated in an umbrella education act. Learn Free submits that in the interim, in respect of registration of homeschoolers, the Pestalozzi Trust's proposal presents a comprehensive rights-based approach, and we therefore endorse that approach. Whatever approach is adopted, a freedom of curriculum and assessment clause is essential to ensure South Africa meets its international obligations. Ms. Jennifer Harnakom of the Association of Homeschooling and Advocate Tony Palmer, presenting on behalf of the Pestalozzi Trust, have set out in detail South Africa's international law obligations. These can be summed up in one phrase: minimum is not maximum. To impose on independent education the same contents and skills as are imposed on the state sector, or even predominantly the same content and skills, is to rob the independent sector of the very independence that is protected by our Constitution and by our international law obligations. Advocate Palmer highlighted the recent High Court decision that provides useful guidance on ensuring that minimum standards do not morph into maximum requirements. This case, judgment number 82 of 2022, issued on the 16th of June, a significant date for us, in 2022 in the matter Katholiek Onderwijs Vlaanderen en anderen en Federatie van Rudolf Steiner Scholen in Vlaanderen and anderen considered the issue of what should be minimum objectives. It may be appropriate to mention that according to the Constitution, that our courts may have consideration of foreign law. This case arose because of the education minister of the Flemish community in Belgium facing a common problem, falling education standards, and he sought to address that by proposing new standards. This case involved a comprehensive challenge against the Flemish community decree of the 12th of February 2021, which outlined new education objectives for secondary schools. Various organizations representing Catholic and Steiner schools filed petitions claiming that the decree infringed on the active freedom of education by introducing overly detailed and extensive final objectives, thereby limiting schools' ability to implement their own pedagogical projects and curricula. They argued that this imposition restricts their freedom to offer education based on their distinct educational visions and pedagogical methods. The court found that the objectives overly restrictive and unconstitutional and struck them down. Key principles emerge from this case. One is proportionality, that to put this simply, objectives must allow enough time and space to pursue the unique educational approaches of the schools in question. The autonomy of educational institutions must be respected, that's the second principle, and final objectives should be an absolute minimum standard, not, for example, the over-detailed national curriculum statement we have in South Africa, which is our submission. Two additional principles require mention. These are the community's involvement in setting the objectives and that of lawfulness. Any legislation adopted by the Select Committee will have to be in accord with international law. One final comment on home education relates to the Parliament's engagement process. I'm going to make myself unpopular by saying that while Learn Free rejects the sale of alcohol on school premises, detailed laws are required to regulate the consumption of alcohol on school premises, for example, during churches' communion services, by educators and staff in their accommodation, and when in poor communities, the school hall is the only safe and suitable place for weddings. Yet because of a public outcry, this clause was summarily removed. The question arises why the homeschooling clause, which received a similar level of rejection, and dare I say on a more substantive basis, remains in the bill. Learn Free's recommendations are therefore the following: that the bill be paused in the National Council of Provinces while a comprehensive package of education legislation is prepared to allow us to meet the challenges the educational sector will face in the next decade. This should start with an umbrella education bill based on our international treaty obligations and incorporating principles from the Children's Act and the Child Justice Act. To this should be added an ECD bill and potentially an LSEN bill as well. Homeschooling should be removed from SASSA and added into the umbrella education bill. Hybrid education should be added to this education bill. Independent micro schools and online schooling should be included in the Bella bill. The last 3 days have seen a careful forensic dissection of the Bella bill. It would be difficult to see how this Frankenstein bill can have life breathed into it at this stage. Whatever is the root cause? Why after 10 years can a bill be so flawed? The answer we submit is simply the lack of proper participatory democracy. In Bekink's Principles of South African Constitution, or second edition, the author states at page 81 that participatory democracy refers to the participation of individuals and institutions in government processes that have effect on them. The author goes on to state that participatory democracy is well established in the legislative branch, as today's proceedings illustrate, but is much less developed in the executive branch. This brings us to the case of Bella Bill's missing twin. The National Education Policy Act and the Schools Act are the twin bills that created the post-1994 education dispensation. However, SASSA is being changed at the moment, but NEPA has been neglected. SASSA should not be passed into law until NEPA is reformed to accelerate, democratize, and improve the quality of policy development and reform the policy-making process. Such a reform should entrench procedural rights and create an environment supportive of soft law to cater to emerging educational modalities. And if we have this fundamental reform, we will reform the policy-making process. By the time bills get to the National Council of Provinces, the level of dispute that we see over the current bill will not actually be taking place. Chair and members of the committee and all the presenters and members of the public, thank you very much for your time.
Yes. This thing freezes from time to time. Thank you very much, and Dade Kodero, for your presentation. we really appreciate that. Thank you very much, members. Do you have any clarity-seeking question to the presenter, so that when we present, we don't have to think about calling him back to say some of the things that needs to be clarified? Over to you. I'm going through our system here. I don't see any hand from the members. So therefore, thank you very much for your presentation. And the committee will make a determination, and that will always, it happens in the public domain. The information, sure you will get it and know what the committee has decided upon. We're giving this opportunity now to Homeschooling Association South Africa. They are represented by Mayor Rebecca Liebenberg. Mayor Liebenberg, the platform is yours.
Thank you very much, Chair. Good afternoon, dear honourable committee members, chairperson, and my speakers in arms. My name is Rebecca Liebenberg, and I am the founder and director of HSSA, a parent support group that grew organically over the years to eventually become a national relevant homeschooling association for South Africa. I knew about how effective support groups are from personal experience because I really struggled as a teen with many health issues, and what felt to me was something like an apocalyptic social challenge. I shudder to think what would have become of me had I been a teenager in today's world, instead of the one I had, where phenomenal support and sensible guidance came from teachers, family, and friends alike. It is from this perspective that I started a homeschooling support group for parents. Sorry? Hello? Can I continue? I'm not sure if anybody...
Yes, ma'am, you can continue.
Thank you. Okay, so from this perspective, I started a homeschooling support group for parents who felt incompetent to take on full responsibility for the education of our children. That was 16 years ago. A support group draws together all kinds of people who have common experiences or concerns and who provide each other with encouragement, comfort, and advice. Our group grew steadily as the people who populated it provided for each other and created a space to share personal experiences and feelings and coping strategies. What made this so useful and effective was that we were and are able to share firsthand, tried and tested best practices that benefit our children. There aren't enough books or teacher training colleges or universities that can compare to the worth of a mom or dad's word on how and what and when to manage the typical and atypical challenges a parent faces on a daily basis as they fulfill the roles of provider, friend, teacher, nurse, taxi driver, policeman, bouncer, banker, therapist. For almost a decade, our support group grew in leaps and bounds, and we bonded as a community and learned to become better parents, better spouses, better role models for our families, our communities, and each other. Any homeschooling parent can tell you that homeschooling taught them just as much as it taught their children. The learning lifestyle is not only for the recipient of information in a home education setting. Rather, it creates an exponential growth of talents and aptitudes and interests of all who are part of the journey. And it is a journey. Homeschooling is not just a year's sabbatical from mainstream living. Homeschooling is a very unique, long-term system of connected processes that reaches the same end goals anybody else would in life, except the experiences along the way are wonderfully different. Please don't pass laws that rob us and our children of these rich experiences. And don't listen to the jealous rantings of non-homeschoolers who spew hate speech due to fundamental ignorance and media propaganda. I tell you all this dramatic, touchy-feely stuff because I have come to realize that it's futile, fighting for something and motivating for something that even being the living evidence of something, if your audience doesn't have a heart. I may just be one mom here before you, but with me in solidarity stands another almost 28,000 from our community who subscribe to the alternative education sector. Homeschooling is the main protagonist in the story, as we know, but many characters and genres could fit into that definition, and it could be far greater than you are aware of if only our leadership, who are mandated to serve the citizens, would give us a gap to offer thorough information, compelling evidence-based research, and once we've established a good line of communication with you, any baked goods you might enjoy. I'm really hoping to pull on your heartstrings right now because I want your attention. I want you to listen to what we are saying as a community. I've been praying that our words will fall like a drenching rain that sinks into a rich soil of your heart, and that compassion and understanding and tolerance will sprout so that you may recognize us and see our rather bizarre plight of having to defend our children from the very ones who are supposed to be our backup and guidance and pillar of strength. That's you. South Africa has been through enough, and many struggles have built character in all of us, but we really do need some breathing room for that to flourish and develop into a sense of agency so that our subsequent generations can see our country as a springboard into life rather than a claustrophobic nanny state to run from. We can't expect our children to want to come home if home is unwelcoming. Please think about this very seriously as you contemplate all that we have told you over the last few days. I'm hoping that from our many submissions, with copious repetition of pertinent points of view, that you will be struck by the sheer volume of so many people saying the same thing for so long, rather than becoming dismissive, like the DBE and many from the PCBE. We repeat our sentiments because they are worth repeating. Our children are worth that effort, and we are not going to give up until we have found a rational, reasonable, and peaceful compromise with our government. So what's wrong with the history of the Billable? The Billable's efforts to align the South African School Act 84 of 96 and the Employment Educators Act 76 of 98 with developments in the education landscape have not taken into consideration that the developments over the last 5 to 10 years requires the outdated elements of the amendments to be reviewed as a matter of urgency. We understand that the planning and turnaround time for these things are long and the efforts are tedious. However, for education reform in a country with as many unique hurdles as ours, we need to apply the same principles that we do to our own learners. Assessment and intervention cannot happen every 15 years, and we won't ignore it or discount almost a lifetime's worth of applied effort, development, and changing needs of our learners. So it behooves me to point out to you that this is exactly what's been going on under your noses at the DBE. I must hasten to add here, however, that over the last 4 years or so, I've had the privilege and blessing to get to know some of the staff within the DBE structure, and it's difficult for me to say these things with them in mind. They're good people who work exceptionally hard, and they spend sleepless nights worrying about the children in our country. As with any career in education, being a cog in the system is difficult. The work is emotionally draining and sometimes downright heartrending. So it's more of a calling than a job. Their individual excellence, unfortunately, cannot buffer the slack stewardship we have seen from the body or the collective of the whole department. Many of the clauses in the bill come from efforts and documents produced prior to 2014, which is an entire decade ago, and during which decade the DOE and DBE had received copious amounts of public feedback about what they told us they were planning, but which was subsequently disregarded. All the meetings with our sector up to 2020 were not open to the public. Imagine that. They were not open to the public. Instead, the DBE chose to consult with only a few in our sector, stakeholders and role players that they deemed privileged for that role. This lack of transparency was aggravated by further withholding of information. The meeting's minutes and resolutions were also withheld from our alternative sector, and stakeholders and role players, as we are those, were asked to offer commentary over the years without having been given full disclosure or even information with which to make informed choices and decisions? How could we give comprehensive commentary in response to proposed regulations that directly impact our daily personal lives? By the time planning for the implementation phase commenced around 2019, 2020, our membership, then brand new line of communication with the DBE, became pointless in the face of a done deal in which the vast majority of our sector had had no opportunity for participation at all. We didn't realize this at first, and the roundtable meeting actually gave us some hope that at last we could be heard on what it is we do in home education. Alas, that turned out to be a farce, much like this recent process has been, with officials merely going through the motions to get to a predetermined point. The purpose of public participation in our participatory democracy is so that we can participate. The participation is meaningless for democracy if our efforts are shelved or filed under X, while top leadership forge ahead with a master plan that doesn't cater for or take into account or even pretend to serve the interest of South African citizens. The efforts made over the years by those who were privileged to gain the strategic favor of the rather shrewd leadership of the Education Ministry were also frustrated by a large range of administrative challenges and incompetencies. And then the chaos that has ensued during 2020 through 22 meant that by the time the draft bill was tabled, we actually needed to start all over again. And yet here we are. This bill was tabled at a point in its development where it needed an entire overhaul. Given the sheer volume and gravity of changes in the South African education sphere in the last 5 years, actually, never mind the last 15 years or so, and especially over the pandemic period, and due to the subsequent changes we saw in society, specifically with regard to education, so very much of the bill became obsolete, outdated, inappropriate, and even discriminatory before it was fraudulently tabled before the committee in November of 22. Many of us and many representatives of the home education movement, together with various religious groups and parents associations and their affiliates, have repeatedly requested that proper research and consultation be done by the DBE into the education or home education sector specifically. As you've now heard repeatedly from many other speakers and organizations, absolutely no discovery was done into the mechanisms, feasibility, psychology, cost, or other aspects of home schooling. We are still waiting, dear honorable members, for someone in the department responsible for this aspect of legislature to do the job they're paid to do and to do justice to the hundreds and hundreds of parents, teachers, providers who invest all their waking hours and most of the time they should be sleeping to this cause that is driven by our love for all children and our sense of absolute desperation for what they must face 10 years from now. We are also thinking and planning ahead, and we boot that parents will sacrifice their lives for the little faces who look to us expectantly with trust and hope in their eyes. What has happened here is just not going to fly. And while we all came here to motivate and present and unpack aspects of the bill, you and I both know that there's so much more to tackle and that these presentations should serve as a warning from a very patient people who are standing up now to say, please, enough is enough. It's an established fact that although our sector was not really consulted, we sought out the DBE and reached out to engage. 10 years worth of pleading and writing and motivating has been blatantly ignored by that arm of government and is now up to the legislature to right this wrong before it becomes entrenched in the law, enforceable, and carrying severely excessive punitive measures. The matter of punitive steps that criminalize a parent for an administrative fault is probably the single most ridiculous addition to the amendments, and we don't see it as a deterrent, but rather as a challenge to face. As a people who have built a thriving and complex social structure comprising diverse races, religions, and worldviews, our movement spans more than 3 decades of persistent resistance pertinently to institutionalized education. I'm just going to read that sentence again. Persistent resistance of pertinently institutionalized educational forcefulness. This simply cannot be ignored any longer. In the late 90s, our movement saw the birth of a formal and informal home education association, legal defense fund, which was initiated by the early home education families who saw the eventual need for legal protection from our own government. This development alone should stand firmly as primary evidence against the arm of government that is supposed to be responsible for the people's needs for quality education. It is unacceptable that we need to establish mediation bodies between the people and the government to be able to exercise an existing right to home educate our children, according to our own consciences. The only remedy for this set of circumstances for this committee is to launch an investigation into the DBE and DOE to discover why they have set themselves at odds against the parents of school-going children. For the sake of our peace of mind, we will probably always contribute towards legal representative bodies like this, but technically it shouldn't be necessary in a free country like ours. Then during the early 2000s, people organically started coalescing into social groups that catered for their preferred kinds and styles of education. This is blatantly evidenced by the evolution of many private publications spanning the last 2 decades. The well-populated social media channels and groups, and very well-organized grassroots face-to-face groupings of home educators who collaborate to expand their children's sporting, social, cultural experiences outside of the mainstream schooling sector. This is, in fact, your committee's ambit. We are providing, maintaining, and growing an entire sector in our country, and you are about to pass a bill that will curb, limit, prevent, and break down a lifetime's worth of work and effort. This is not a small thing, and we are going to take this as an act of violence against our community. Since the informal micro school sector is not technically part of the homeschooling genre, and cottage schools run by providers don't really fit the description of what home education is, our organization can't supposed to speak for the sector, like so many have rudely spoken on behalf of homeschooling, but we do want to make mention of what we see from our vantage point, which is a mostly unrepresented sector of education in our country. I can't fathom how the actual department that is responsible for this has just sidelined hundreds of thousands of people. So we are here to tell you that we stand in front of them as human shields to protect the good work that they do and to vouch for their relevance and their rights to continue to exist, because the children of South Africa need them. If you as a committee help shut down an entire sector with a thriving economy by passing this bill, then we will have no choice but to conclude that you're either unfit for your position or you're collectively lacking in insight and basic common sense. Not to mention a lack of compassion for the children who have nowhere else to go once the cottage schools are outlawed. Anyway, so where to from here? Since the stakeholders and role players in our sector have been trying to have their voices heard on the nuts and bolts mechanisms of our daily lives, there should be a library's worth of submissions in hard copy and in digital records available to you. I can't speak to systems used by the DBE and hope that you will have access to this, but if you did, you will notice that it is not only the DBE who deserves to be investigated and held accountable for the miscarriage and dereliction of duty towards our sector. Sadly, within our sector, we too have parents, teachers, organizations, and business owners who have been manipulating the education sector, the process of making laws, and now even this committee for the express purpose of fiscal gain. While we all have the right to earn, this right should never be an infringement of our individual and personal rights to choose for our families and ourselves, and especially regarding what approach to take in the education of our children. Your way is not the only way, and we can prove it. One prime example is that homeschoolers are already being denied permission to home educate if they dare to be honest about using online support. This is unacceptable. It proves that registration, which is in clause 35, is not what it purports to be, and the DBE is holding our rights to educate at home hostage to some background plan to monetize the part of the private sector that serves our communities. What exactly are you going to do about this, honorable members? As has been mentioned by other presenters over the last few days, and one in particular, the white paper holds that parents or guardians have the primary responsibility for the education of their children and have the right to be consulted by the state authorities with respect to the form that education to take and to take part in its governance. We haven't taken part. I've shown you how this is not and is not what is happening, and how this bill will make sure it will never need to happen. We will be absolutely limited. Parents have an inalienable right to choose the form of education which is best for their children, particularly in the early years of schooling. So please do the right thing and send this bill back to where it needs to comply with the law and make it subject to reasonable safeguards. Please, it needs to be subject to reasonable safeguards. As I've mentioned already, the members of our sector value their autonomy, and they do not want mediation bodies set up to negotiate terms of engagement, or for regulatory bodies born of nepotism and cronyism to arbitrarily design standards and norms for practices they don't understand, represent, or participate with. We vehemently reject this bill because of the implications of many of the amendments, and along with it, we reject the DBE's silent partner interests and the underhanded behavior that threatens to lay capture of our sector for the sake of making a buck on the back of innocent children's future. Right, so now that you know who we are, that we are many, and that we are fully aware of the state-led and private sector shenanigans, you can appreciate that we mean business. So let's try and quickly unpack this thing before the weekend starts. I see I've gone just over half my time already. 30 minutes is not really enough to focus in detail on all the amendments we would like to. So we're just going to offer an overview of what needs to be renegotiated, let's say, and addressed so that we can indeed have education reform and some sensible laws to live with. I had more to offer along the lines of how these amendments infringe on some of our constitutional rights, but you've heard from many speakers on this, so I am amending my presentation to relegate just a mention to this. And when the time comes, we are happy to go directly to the Constitutional Court and battle it out there to claim our rights, if further blatant disregard were to ensue. As was mentioned in another presentation before mine, the state has an obligation to respect, protect, and promote these rights in terms of not only the Constitution, but also international covenants the Republic is signatory to, including the Convention Against Discrimination in Education, the International Covenant on Economic, Social, and Cultural Rights, and the Convention on the Rights of the Child. This is no small matter, and the people will hold you accountable should our children be put in the line of fire. So we are looking at just a list of main concerns with certain clauses, not all of them. From our homeschooling perspective, we obviously feel we can't really have a say on everything. So this is what affects us. These clauses are 1, 2, 3, 4, 5, 6, 7, 14, 15, 16, 18, 19, 33, 39, 41, 42, and 50. All our previous submissions refer. I will focus on those that have the most significant impact on our sector and our membership. Apart from the overriding theme of excessive empowerment of national and provincial education department heads to overrule parents' and children's rights and wishes, and teachers' autonomy, teachers are people too, and they often stand instead of parents. So you're going to be putting them in an impossible situation. And of course, the rather bizarre manner in which school governing bodies will become tokens of governance with no real authority to protect their communities or even just recourse to possible corruption from the government. In its current form, as per the mentioned clauses, the bill constitutes an infringement of various rights of parents and children and teachers, in that the wording contradicts international treaties upheld by our country. As I and others have pointed out, these amendments seek to make laws enforceable with jail time based on zero research, and the local and international data that is available has not been considered either. We've heard from the DBE and its agents at every public meeting, and it must be noted that the explanations and motivation going on in those presentations have served to alert the public to the discrepancies between what is actually written in the bill and what the officials try to convince us is meant by them. I point you here to massive irregularities going on in the public hearings over the last 10 months, where members of the PCBE committee and even some on your provincial committees have interrupted and prevented speakers who come prepared with proper statistical data to prove that our citizenry don't want these amendments. I personally witnessed 3 such such instances in Gauteng, the Eastern Cape, and in Mpumalanga. We ask that you launch an investigation into this matter of lack of communication to the public prior to the meetings, and obviously the massive irregularities that are still currently going on. And we also ask that you instruct the relevant responsible body to conduct a decent socioeconomic impact assessment. For homeschoolers, this bill will incur massive costs. So we may as well put that money into fighting for our rights to protect our children from dangerous schools and dubious ideological academic content. I'm going to run through these as quick as possible. I see I only have 10 minutes left. Clause 1, the definitions are expanded in ways that infringe on standard norms. Clause 2 is a lack of definition for just cause, and it also doesn't cater for homeschooling specifically. Clause 3 is purposed to prevent the school dropout rate. This clause has failed. Our submissions refer. Clause 4 is interesting because it highlights a no discrimination policy and documents for admissions to schools. And I'd like to compare this to homeschooling. To start with, final authority is not a phrase that should exist in any law. So that needs to be removed, please. And the admissions policy is subject to the HOD. And if that is the case, it should have very clear parameters if government wishes to have this level of oversight, so as to avoid future abuse of any vague meaning or future regulations that are abhorrent to society. So if we look at this and we see that a lack of documentation cannot withhold a child's right to education, we feel that this should be equally applied to the clause 35 for homeschooling, where if our lack of documentation is evident, that becomes part of the criteria for permission to homeschool. So we don't get permission because a document might be missing. And a document might be missing because the Department of Home Affairs hasn't functioned for 10 years. It's not the parent's fault. It's not the child's fault. We should not be held responsible for consequences that are beyond our control. And then on top of that, be lumped with a punitive measure that could see us sit in jail for a year. Clause 5 caused much angst for the public over language policy fears. The government has just not done its duty in informing the public timeously or with enough detail. I personally don't have an issue with it, but there are many homeschoolers who have reached out to me who say they have absolutely a huge issue with it. So as an organization, we do ask for this to be revised. In clause 6, the national curriculum statement is mentioned, which pertinently refutes what we've been told by the DBE, that this bill does not address curriculum. I'm going to skip a few clauses and go to clause 14. While it's not strictly homeschooling related, the implications of this clause that refers to continually changing norms and standards and something called identified support material based on criteria expressed as innocuous adjectives like effective and efficient. This very small amendment, it's a tiny little clause, comprises a change of only 10 years. But it's going to entrench a precedent of content selection that is subject to nothing other than the sentiments of whoever is vested with the absolute power this bill seeks to attain over the entire education sector. We are part of that sector, and we are being told that much of our content will need to comply to what these amendments stipulate. The real risk here for home education lies in the procurement of prescribed academic material. We don't have or want a governing body, which clause 6 might enforce on us, by the way. Parents don't want a middleman making arrangements and decisions for the learning lifestyle and aptitudes and interests of children who were pertinently removed from the mainstream system for that very reason. I've got on the screen punitive clauses, which you can read, but I will continue going through my clause to clause. Clause 15 speaks to clause 6 and 14, in that the consultation with governing bodies is meaningless if their functions could be adjusted for the purposes of agreement with enforcement. Reasonable grounds means that each governing body will have to motivate, fight, and fund resistance to unsavory changes to a school, where such changes also impact local social spheres. If an impasse is reached, the HOD might declare it's an urgent case, which this provides for, which will neatly sidestep the governing body anyway. making all the wordiness of limitations in the HOD an absolute waste of ink on this bill. The DOE and DBE seek to an inordinate amount of power over schools, and as homeschoolers, we worry about this for the sake of our children who might want to go back into the mainstream system at some point of their education journey. It is in our interest to speak up about this. Phrases such as sufficient reasons should not be used as vaguely as they are, because it confuses interpretation, and we feel this may actually be intentional. I'm going to skip to clause 19, which is about more regulation of the governing bodies, which could erode local community camaraderie and break down years' worth of soft skills development, interrupting progress and stripping experienced yet unqualified members of their usefulness to the community. This is a dismantling of a people. It's cruel and unusual treatment of those who gave of their time to build a better South Africa. Clause 33, penalty for unregistered independent schools, that's just not acceptable. I'm still struggling to understand how a Department of Education can stop schools from existing. And they haven't even given good enough reason, and they've done no impact studies for this as well. That brings me to clause 35. This must be removed and reworked. We actually need our own document for this, because it's all about homeschooling. It needs its own document because the sector is so much more complex and vast than the DBE pretends it to be. We've actually written a heck of a lot on clause 35, so I'm actually going to not go into depth with it because I see I'm running out of time. Clause 39 is an interesting one. One person can't have so much power as to cause regulations to become a subsidiary law and then use that as an implementation strategy later on down the road. It's just really not on for our sector. And clause 38, which is a general absolution of liability for the department and possibly government in general, will allow them to do exactly this. The injustice of enforcement without fair recourse is inconceivable in a democratic society. This can't happen. This bill incurs costs, prevents cultural appreciation, and strips us of our social rights as homeschoolers. How on earth is this even getting past the committee members? This kind of lip service to the people has reached the end of its efficacy, and no one is impressed. The fact that we are members of the African Charter, and it says it focuses on the rights and welfare of children, while most of Africa is developing academically, that's what they say, and yet it's actually falling deeper into famine as African countries' debts pile higher and higher. We're not developing academically. The welfare is not being taken care of. The lip service is too much. We are indeed following a trajectory, but not the actual principles as has been offered and as evidenced by the collapsed education system, deserted school buildings, and barely functional hospitals that can't use their phones because the government didn't pay the bill. Homeschoolers remove themselves from this chaos because it is not in the best interest of our children to suffer such consequences for which they are not responsible. Clause 35 really needs to be removed from this bill so that our sector may negotiate with the DBE for a bill that will help and guide and support home-educated children instead of criminalizing their parents for the sake of an administrative fault of refusing to enter into an agreement during the process of registration for home education. I thank you very much for giving me an extra minute. I really appreciate that. I don't think I've finished. Yes, I did finish. That was my last slide. Thank you. And if there are any questions, I'm willing to answer them.
Thank you very much. My honourable members, if there are questions that members would like to ask, points of clarity on the presentation, you may raise your hands on this platform, and then yeah, you can then engage. Looking at the hands set here. I don't see any raised hand on the platform. And so I'll therefore thank you, Melibenberg, for having made this time.
Thank you very much.
Presentations on matters that you can hear very close to your heart. Thank you very much.
Thank you.
We taking this platform now, giving it to, let's do it together for education. And there is Ubabo Naresh Badal. Dr. Badal, you are.
Good afternoon, Honorable Chair and committee members. Thank you so much for this opportunity in allowing me to present today. My name is Naresh Badal, and I am presenting to you on behalf of Let's Do It Together for Education, a registered non-profit organization and a registered public benefit organization. Our aim is to increase access to education and improve educational opportunities. The purpose of our presentation today is to ask for an amendment to the Bella Bill, in particular Clause 33. Our concern is the lack of recognition for micro-cottage centers. Micro-cottage centers, as the name suggests, are small-scale educational centers, often operated from private homes and cater on average for between 5 and 25 learners. They are regarded as illegal because they cannot meet the registration requirements that are designed for large schools. Clause 33 imposes penalties, increased imprisonment of up to 12 months, or a fine, or both a fine and imprisonment for persons that operate micro-cottage centers. Within our existing education legislation, there are two categories of schools: public schools, which are governed by the state, and independent schools, commonly known as private schools, which are privately owned. Independent schools are obligated to undergo registration with provincial education departments, adhere to various governmental regulations, and apply to Umalusi for accreditation. Within the independent schooling sector, there is a category known as unregistered private schools, which are regarded as illegal. These private schools are educational institutions that function independently of the formal government-regulated education system, without official recognition or accreditation. Micro-cottage centers are classified as independent schools. The South African Schools Act does not accommodate them, and they are expected to follow the same registration process as large schools. This current regulatory environment is not enabling for micro-cottage centers. It is creating barriers and significant challenges and risks in our education system. Home education has gained significant popularity and is the fastest growing education sector globally. The landscape and dynamics of education in South Africa have changed, and this change is influenced by a number of factors, including continuous advancements in technology, new generation learners, and individualized learning needs. The momentum at which the winds of change are blowing is propelling education forward faster than ever before. When micro-cottage centers initially emerged, they addressed not only the lack of alternative and affordable private education, but also the difficulties faced by parents who wished to provide their children with advantages of home education, yet were unable to do so for various reasons. We are witnessing a surge in micro-cottage schools, providing alternatives to traditional schooling. These centers have adapted to fulfill the need of non-traditional education, providing structured learning atmospheres similar to home-based education. They cater for a range of educational philosophies, curriculum choices, and learners' needs. As per Stats SA, we currently have just under 2,300 registered private schools, but there are well over 3,000 micro-cottage centers. There is also some evidence to suggest that there are possibly close to 5,000 micro-cottage centers in existence across South Africa. In 2022, we conducted an informal survey in which we interviewed micro-center owners. We acknowledge that this survey is limited to 63 center owners only, and this is because unregistered centers are afraid to participate as they fear exposing themselves and being forcefully closed. We also acknowledge that this survey was only limited to centers operating in Gauteng. However, the information obtained is extremely valuable. 95% of micro centers have less than 25 learners. In the context of comparisons, there is about half the number of learners in one public school classroom. Almost half of these centers have learners with special educational needs, and/or barriers to learning. 18% of centers follow an alternative curriculum. The preferred choice of alternative curriculums within these centers are the British International Cambridge curriculum and the American core states, which are both comparable to CAP's curriculum. 88% of centers are owner managed and the owner is a SACE registered educator. All centers that we interviewed, parents are registered with a curriculum service provider, where the curriculum material is provided by the curriculum service provider. 93% of these curriculum service providers also provide assessments. 92% of centers are operated from the homes of the owners, where some alterations or modifications have been made to accommodate teaching and learning. The majority of centers, and not just the centers that we interviewed in the survey, but the centers that exist across South Africa, are not opposed to registration, but there is no support for the challenges that they experience. They simply just cannot meet the requirements for registration. The first step in the registration process is to register with the Provincial Education Department. Centers fail to meet municipal requirements, complex and costly rezoning, health certificates, fire and safety certificates, and Provincial Education Department management standards that are written for big schools. If a center does succeed to register with a Provincial Education Department, they must apply for accreditation from Umalusi. The cost of accreditation with Umalusi, if a center does succeed in their attempts to register as an independent school for grades 1 to 9, is approximately 150,000 rands. Fees are paid in different steps in the accreditation process, and if you fail, there are additional reassessment fees, which is estimated to be around 70,000 rands. No micro center with less than 25 learners can afford to pay registration costs of approximately 200,000 rands. Based on a report from Umalusi on accreditation and monitoring of private educational institutions and private assessment bodies for the period of 1st of April 2021 to the 31st of March 2022, there is an increasing number of institutions that apply for accreditation and fail. The implications of failed registrations or unregistered centers that continue to operate illegally present significant concerns, challenges, and risks to the education system, learners, and parents. The implications of this unregulated environment are far-reaching. Students are subjected to inconsistent standards of education, with the quality of instruction and curriculum delivery varying widely. The qualifications and competence of tutors are not verified, potentially compromising the educational experience and outcome of learners. Furthermore, the absence of a regulatory oversight creates opportunities for exploitation of parents with dishonest practices and misleading information. Questionable curriculum delivery undermines the educational development of learners. The absence of transparency and accountability also erodes trust between relevant stakeholders. Without proper regulation, there is limited assurance that learners attending these centers receive a quality education that meets minimum standards. In response to these concerns, Let's Do It Together for Education has established the Standards Commission for Independent Alternative Education Centers, a quality assurance body addressing the need for effective quality control in educational standards, safety standards, and ethical practices. We have established a Standards Commission to help recognize these micro-cottage centers. Our framework provides clear guidelines and standards for these alternative educational centers that are already operating and provides guidance to those who want to establish similar centers. It includes educational standards, safety standards, operating standards, and ethical practices, protecting the rights of parents and learners and promoting transparency and accountability in this sector. When micro-cottage centers first emerged, they were in response to the absence of alternative and affordable private education. Now it has come to mean not just the absence of alternative and affordable private education, but the exclusion of educational centers that do not qualify for registration that is written for big schools. Micro centers play a pivotal role as the true embodiment of the missing middle in education. They offer tailored, personalized learning experiences, catering to students who flourish in such environments. There is no clear and formal definition of what a micro-cottage center is. There is no policy guidance on the procedure for the establishment and registration of such a center. In the absence of a definition of what a micro-cottage center is, the Standards Commission for Independent Alternative Education Centers defines micro-cottage centers as independent alternative education centers. And these are educational institutions that operate independently, is not registered as a traditional independent school, but is quality controlled and registered with a Standards Commission that offers alternative approaches to education and enrolls learners in one or more grades from grade R to grade 9. The defining feature of what an independent alternative education center is its independence from mainstream schooling while still adhering to regulatory standards for quality and safety. The purpose of the Standards Commission of Independent Alternative Education Centers is to provide quality assurance that helps maintain and improve the quality of services offered by micro-cottage centers. This not only benefits parents and learners, but also enhances the reputation of centers. Establishing and maintaining centers which ensures consistency and uniformity, making it easier to assess and compare quality across different centers in different regions. To create accountability for micro-cottage centers, ensuring that they are responsible for the quality and safety of their services and learners. This encourages ethical behavior, transparency, and integrity in the sector. Quality control processes that encourage micro-cottage centers to continuously monitor, evaluate, and improve their operations. Ultimately, regulating and quality controlling micro-cottage centers helps to protect public interest and maintain the reputation of the entire sector. Ensuring that parents have positive experiences with micro-cottage centers is of importance. The advantages of having a Standards Commission for micro-cottage centers. Our quality control framework promotes educational quality and accountability. It ensures centers adhere to educational standards, safety standards, and ethical practices. We grant centers legitimacy in the educational landscape. It demonstrates their commitment to meeting and maintaining educational standards, which enhances their credibility amongst parents and educational authorities. We promote quality assurance by establishing guidelines and criteria for educational practices, curriculum implementation, tutor competence, and learner well-being. Through regular monitoring and evaluation, centers registered with us can continuously improve their educational offerings and provide a high standard of education. This ensures that learners receive a quality education and are protected from potential educational deficiencies and reduces the concerns the Department of Education has in the existence and operation of unregistered centers. We prioritize the well-being and safety of learners. By registering with the Commission, centers commit to meeting safety standards, ensuring adequate facilities, and employing qualified tutors. This focus on learner well-being provides the Department of Basic Education with peace of mind, knowing that children are in safe and nurturing learning environments. We offer training and development opportunities to centers, and their participation in these initiatives enhances their skills and expertise of their tutors, enabling them to provide high-quality learning experiences for their learners. The Standards Commission serves as an advocate for registered centers, representing their interests and needs to educational authorities and stakeholders. This collective voice can contribute to shaping policies, gaining recognition for the important role micro-cottage centers play in the educational landscape. This advocacy aims to shape policies and standards that support the growth and legitimacy of the sector. Our strategic objectives serve as a guiding framework. They provide a roadmap for us to pursue our mission effectively by outlining specific areas of focus and desired outcomes. These strategic objectives allow us to align our efforts, resources, and initiatives towards common goals, ensuring coherence, efficiency, and impact in quality controlling microcenters. It also provides a basis for evaluation and accountability, enabling us to measure our progress, identify areas for improvement, and adapt to changing circumstances. Our operating standards outline the expectations and requirements for centers. These standards aim to ensure that centers provide quality education in a safe and inclusive environment, supported by competent staff, effective curriculum, and ongoing evaluation and improvement processes. We have a code of conduct for independent alternative education centers. It is a set of ethical principles and standards that guides the behavior and practices within this educational environment. It emphasizes the importance of fostering a positive learning environment characterized by respect, integrity, professionalism, and child protection. Our code of conduct underscores the significance of compliance with regulatory standards and continuous professional development to ensure the delivery of quality education and the well-being of learners. The performance and monitoring criteria that we outline is designed to ensure continuous assessment and improvement of micro-cottage centers through systematic evaluation across various domains, including academic achievement, curriculum implementation, compliance with standards, teaching and learning practices, student engagement and well-being, development, continuous improvement, feedback and evaluation, and adherence to ethical and professional standards. The Commission aims to uphold the quality of education and safeguard the interests of learners and stakeholders. These performance monitoring criteria serve as a vital benchmark for monitoring micro-cottage centers, identifying areas for improvement, and fostering a culture of accountability and transparency. The aim is to promote excellence, innovation, and inclusivity in micro-centers, ultimately ensuring the delivery of high-quality education and holistic development opportunities for all learners. Why should we use the Standards Commission for Independent Alternative Education Centers? As a quality control body, we help to establish and maintain standards for curriculum, teaching methods, and assessment practices. This ensures consistency and uniformity in educational quality. Centers that adhere to established guidelines and regulations promote accountability and transparency, reducing the likelihood of unethical practices, fraud, or non-compliance. It helps us to level the playing field, ensuring that all educational institutions, regardless of their size, location, or resources, meet minimum quality standards. This promotes equity and access to quality education for all learners, regardless of their social, economic background or geographic location. Our quality control measures implemented help to identify potential risks and vulnerabilities in the education sector. By conducting regular assessments, evaluations, and audits, we can proactively mitigate risks related to educational quality, safety, and compliance, thereby safeguarding the interests of learners, educators, and stakeholders. We can hold educational institutions accountable for the quality of education they provide. Through monitoring, evaluation, and accreditation processes, we can assess their performance, identify areas for improvement, and ensure that centers take corrective actions when necessary. Despite the obvious advantages of saving the state money, filling the gaps of the lack of public schools, Generation Alpha learners often thrive in environments where individual needs and interests are acknowledged and catered to. Micro-cottage centers with their smaller class sizes and more intimate settings can provide personalized attention and customized learning experiences tailored to each student's learning style and pace. Micro-cottage centers can specialize in catering to diverse learners, including those with learning disabilities, neurodiverse conditions, or special educational needs. They can offer tailored services and support and adaptive technologies, as well as individualized attention to help those learners thrive academically and personally. Micro-cottage centers may embrace alternative education curriculums, such as Cambridge and the American Core Curriculum, and philosophies and methodologies such as Montessori, Waldorf, or project-based learning, which allows learners to explore their interests, develop critical thinking skills, and engaging hands-on learning experiences beyond the traditional classroom setting. Our learners today are from Generation Alpha, and we need to accommodate them. As an independent alternative education center registered with the Standards Commission, in the eyes of a tutor center, parents can be rest assured that their child's education at an education center is of utmost quality comparable to that of a private school. Although the center is not officially registered as an independent school, they uphold the same rigorous standards and commitments to excellence. And they provide the same level of quality education available in an independent private school. Microcenters are not competition to large independent and public schools. They are certainly not a replacement for them. Micro-cottage centers are a beacon of hope and a solution to bridge the gap between traditional schooling and the demands of parents. The nature of whether parents opt for prestigious, large-scale, expensive, registered independent schools or smaller, informal, quality-assured, unregistered cottage schools that have far greater flexibility in their approach to education should be of secondary importance, with the primary focus being on the school's ability to deliver high-quality education. The Bella Bill offers us a chance to grant micro-cottage centers the acknowledgement they deserve. Let's Do It Together for Education requests that provision be made in the bill for such centers to be quality controlled and be given an opportunity to gain recognition. We don't want to create a separate education system. We want to increase educational opportunities and improve access to quality education. With this, we can expand the private schooling sector, which benefits everyone in society. Our written submission includes our framework, which you can view. We would also like to state that we support First Education Research Group and Learning Cat proposals. With this, I thank you so much, Chair, for allowing me to present today. Thank you.
Sorry, I was thrown out of the meeting. Hi, Noltando.
Hi, Chair. The presenter is finished.
Oh no, I thought there's something wrong with my phone because I was thrown out of the meeting. I've just now reconnected. Thank you very much. Are there questions of clarity based on the presentation? I'll check from my gadget. I don't see any hand. And in the absence of any hand, I'll take this opportunity to thank Naresh Badal for having made time to come to the committee and talk and actually talk to us and make a contribution toward the debate. Thank you very much. All members, there's the name of Mayor Tanya Funis. She's a private candidate, not representing any organization. So I took liberty to invite her to the meeting after having lots of correspondences to and fro between her office and mine. Let's hear what she has to say to us. Mayor Tanya Funis, if I'm pronouncing your name very well, the surname well.
Yes, thank you very much. Are you able to hear me?
Yes, I do. You're loud and clear.
Thank you. Thank you. I say good afternoon to you all. It has been a very long 3 days of oral presentations for the NCOP Select Committee, and I appreciate that I'm able to speak to you this afternoon on the 8th of March 2024. Chairperson, may I respectfully ask if we have a quorum to continue with this last meeting?
Whose quorum?
Your quorum for the Select Committee, please.
No, the quorum starts when we hold our meeting as the committee. You may continue with your presentation.
Thank you so much. If this was a personal meeting, I would be able to greet you properly and individually, and I would recognize you by saying welcome to this presentation, and I would say I see you and I see you. But as we are embracing technology and that we are moving forward in this artificial space, I respectfully greet each one of the elected members of this committee. As an introduction to what homeschooling is, please could Ms. Kaka play the video that has been prepared and provided to her for 2.5 minutes. Would that be possible?
Within 30 minutes, that is given to all participants. Yes. And for your information, you ask information about the quorum of the meeting. I don't know where that comes in, but we do make a quorum in case you have problems with presenting whether you think there is no quorum.
Thank you very much, Chairperson. Ms. Kaka, are we able to play the video? Are you able to put the sound on? There is no sound. Hang any of the music.
I'm just seeing pictures. I see movies. I don't hear anything.
So you are meant to be seeing a video with music, but I do not hear it myself.
I see all these nice pictures, but I can't hear any music or. I wonder if you could just talk to the pictures as they appear, because for me, I'm just seeing pictures, very beautiful flowers and books.
The volume was on my side. I'm not sure with that.
No, maybe it was my.
Hi, are you able to hear me now?
Yes, I can hear you very well.
So there was meant to be music to that video. I'm sorry. It was simply meant to be an introduction to the way that I've homeschooled in the past 10 years. Thank you for playing it. As mentioned in the video, home education is protected in the South African Constitution, Section 29 of 2. Home education is an educational alternative. It is regulated by the South African Schools Act of 1996, Section 51. The Basic Education Law Amendment Act, Clause 1, 2, 6, and 35, seeks to change Section 51 in the SASSA. I, as with many other home educators, reject specifically these clauses when it comes to home education. And I'd like to go through a presentation, but due to the sketchy internet issues, I'm going to switch off my video if you don't mind. Would that be all right with you, sir?
Yeah, you may.
Is that all right?
It's the 30 minutes is yours. We can do.
Yes, that is fine. All right. I hereby state that I sadly reject the Bill due to a number of other clauses that can be considered as unconstitutional and may affect the Bill of Rights of the South African public. This requires intense investigation. The procedures observed in carrying out the Section 76 Bill, which is a proposed law, is questionable and requires investigation. At PCBE level, numerous irregularities and discrepancies were observed. At provincial legislature phase, the Mpumalanga province, it was observed that a number of irregularities and discrepancies were seen. Although further public hearings took place, it seems as if they were not meaningfully or reasonably conducted. Other provincial legislative public hearings have noted other irregularities, such as the billable in totality not being provided to the public at these hearings, only summaries. as well as information being shared that states that children are not allowed to speak at these public hearings. This is a direct contradiction to the Convention of the Rights of the Child, Article 12 and Article 13. Article 12 says children have the right to give their opinions freely on issues that affect them. Adults should listen and take the children seriously. Article 12.2 says, for this purpose, the child shall, in particular, be provided the opportunity to be heard in any judicial and administrative proceedings affecting the child, either directly or through a representative. It has been observed that not many children and learners of school-going age, as defined by either SASSA of 1996 or the Bella Bill, have spoken up about this bill that has a direct impact on them. Those who have attempted to freely express their views at PCBE and particularly at provincial legislature have not been heard and have been discouraged with incorrect information being shared at the conclusion of certain provincial public hearings. It is also observed that a number of opening presentations of the provincial hearings have intimidated the public from speaking about the Bella Bill. I now move on to the lack of research regarding the home education sector. During PCBE level, the SEIA, the Social Economic Impact Assessment, that has already been mentioned by the Cape Home educators earlier today, shows a lack of research on the home education community. The DBE remarks regarding the lack of research that it is unjustifiable on the 16th to the 17th of August 2023, and this is not excusable. The DBE should have conducted meaningful research on the home education sector prior to wanting to regulate it. During and after the PCB level, only 2 of the draft provincial reports that were deliberated upon have been found on the Parliamentary Monitoring Government website. These draft reports, all 9 of them, were deliberated upon and adopted in the and consolidated into the revised national report. So logically, never mind constitutionally, these reports should be available to the public upon request. This is a clear indication of failed communication and the meaningful engagement with the stakeholders. The home education community was not consulted in a meaningful way. Many from the home education community were excluded from any consultations referred to in the PCBE deliberations, whether by intimidation or greed. The DBE could not have communicated with, in the very least, the home education parents that have been registered with the DBE to date. The DBE has not communicated with these registered homeschoolers. The home education community, consisting of many parents, were not made aware of by the DBE that the Bella Bill, as well as the policy on home education, would have such an impact on its community. No communication and no public participation awareness education was conducted directly with them. The DBE assumed that it had communicated to the entire home education community, yet unfortunately it had not. I would like to bring to your attention of the PCBE meetings, Annexure 1, the matrix of submissions that were made to the Bella Bill, as per my written submission on page 7. It is quite clear by this graph that the then clause 37 on home education was rejected. It was an outright rejection. This matrix indicates that the home education sector does not support this bill, even at PCBE level. Furthermore, information regarding this can be obtained from the Dear South Africa presentation and report by Mr. Rob Hutchinson. As per the 8th of August, 2023, the Bella Bill that was presented at the National Public Hearings report with the Deputy Minister states the purpose of the amendments to legislation is to change the wording and the scope of the law. Why is the Bella Bill being amended? One of the mentionings is the criminalization of parents who do not ensure that their children are in school, as well as encouraging homeschool learners to be registered. Please have a look at clause 1G and see that the overregulation of just this section does not encourage homeschool learners to be registered. And this is only in the definition section. Clause 2 that will criminalize parents does not encourage homeschool learners to be registered. As a home educating parent of about 10 years who is registered with the Gauteng Department of Education and has experienced a very positive relationship since registering, I would like to point out that the additional documents sent to us those many years ago were administratively burdening then, and on top of clause 35, the additional documents that will be required for home education registration and the phase assessment now will be unacceptably administratively burdening. Homeschooling was illegal under apartheid, and parents who wished to homeschool their children then believed that that was in their children's best interests. They were imprisoned and their children were sent to orphanages. Democracy in South Africa has made homeschooling legal. Article 20 of the Basel Charter 1990 provides for parental responsibilities, stating that parents or other persons responsible for a child shall have the primary responsibility for the upbringing and development of the child. Parents who homeschool their children and or use the services of a homeschool tuition center or cottage school perform a massive social service and an enormous financial benefit to the state, financially and administratively. Pardon me. In 2017, it was stated by FORSA in their written submission for the Bill that approximately 57,000 children from the public schooling system are otherwise home educated. In Dr. R. Van Roop's recently released report in December 2023, a report named the Report of National Research on Home Education in South Africa, states that there are approximately 300,000 home educated children in South Africa. This research report is the most up-to-date research available to South African legislative decision makers. It is highly recommended that, since no research whatsoever can be found from the Department of Basic Education, unfortunately, on home education and homeschooling, as supported in the SIA, that this report please be looked at.
Excuse me, may you flight your presentation, please? Or is it only me who is not seeing what you are talking to?
My apologies, Chair. I don't have a presentation. I am a home educating parent and I did not have the time to put an entire presentation together. However, my written submission contains all this information that I am reading out to you. May I continue, please?
Yes, you may.
Thank you. There has been a substantial increase in homeschooling since 2017, from around 50,000 to about 300,000. It is estimated that a budget of between 16,000 Rand to 22,000 Rand per child is allocated to educate a child in the public schooling sector, irrespective of the quality of education that they receive. Yet, 57,000 homeschool learners in 2017 saved the state just under 1 billion Rand per year. This is a conservative amount of 16,000 Rand per child per year. If we take that same amount into 2023, and there are 300,000 learners, the home education sector has saved the South African government a whopping 5 billion Rand per year, as you can see on page 12 of my written submission. South Africa spends approximately 7% of the GDP on education. This translates to about 300 billion Rand per year. If you take these numbers, you will see that approximately 15 billion Rand is then saved because home educating parents fund the costs of their own children being educated over and above paying taxes. Hugely contradictory, the Bill states on page 48, under the heading of financial implications for the state, that home educating parents should pay for home education assessments per phase. Unfortunately, these costs seem to be calculated on a senior learner phase and not on basic education as stated by the Bella Bill. These costs are also rather incorrect. Unfortunately, as already stated, this assessment phase cost is not covered in the definition of basic education, but it is at FET phase. This is an additional financial burden on the home educating parent and is not a financial burden on the state. It seems to be suggested that homeschoolers need to comply with the National Curriculum Statement, which is currently CAPS, as per Clause 35, Section 51(2), Number 3 of the Bill. There is no definition for the word predominantly. This could be any percentage. The inclusion of the phrase covers the acquisition of content, results in parents having to have a curriculum that at least covers the content of state-chosen curriculum. This limits the freedom of parents who are entitled to choose from the wide variety of international and South African curriculum, as per shown in my video in the beginning, that is available to us. This shows us that we who wish to educate our children according to Article 18 of the Bajul Charter of 1990 and who on religious grounds, according to the Constitution of South Africa 1996, Section 15, should have the freedom to decline certain content that is contained in the National Curriculum Statement of CAPS. State assessment of homeschooled children's progress. It also imposes a financial burden and additional obligation and/or requirement of homeschooling parents that it does not impose on parents who send their children to public or private schools. It is therefore open to a challenge of unfair discrimination, according to the South African Constitution, Section 9, as well as the Equality Act. According to Clause 30, I would like to end off by stating my conclusion and my recommendations. I have already stated that I reject, and majority of the homeschoolers reject, Clause 1, 2, 6, and 35. I recommend that you remove home education from the public school arena, the SASSA of 1996. However, home education remains legal in South Africa. This is to be done so that home education is not discriminated against in terms of it obtaining the same status as that of IEB or independent schools. A separate act should be proposed to regulate home education. This act must consist of representatives and associations from all provinces. Representative associations and home education parents must include those who are not part of the consultations to date. These consultation meetings and processes must be open to all home education parents and associations and must be conducted in a manner that is fair and non-discriminatory towards all homeschooling families. Current research must be taken into account. The DBE is required to undertake research and conduct a formal survey that will not jeopardize those families not yet registered. It should not incriminate the homeschool families that have not registered to date either. Other supporting forms of alternative education, such as online learning, micro and cottage schools, etc., should be included within this new act. I thank you for your time, Chairperson, and the NCOP Select Committee. I hope that my feedback comes to you with the right amount of respect and care that I have for this home education community.
No, thank you. Our members, are there clarity-seeking questions on the presentation? Let me just check this on the platform if there is any raised I cannot see any request to speak. Thank you very much, Evan. The committee will have a sitting and make their own determination, and obviously our meetings are in the public domain, So you will be able to follow the deliberations of the committee.
Thank you, sir.
And just to assure you that we don't check a quorum for everybody who speaks, but the quorum is checked at the beginning of the meeting. But when a member requests that we should check the quorum before she makes his or her input, we would gladly do that. Thank you very much. Honorable members, that is the Noltando, do we have, I thought we skipped another Laerbur school presentation. Did we, or did we finally? It is not marked on my paper, so on my page, so I thought Martin Pretorius, I think he did make a presentation from.
Mr. Pretorius, he's still not on the platform, Chair.
He's still not on the platform?
No.
Okay. So what do? We forget about him, that we just say that we couldn't get hold of him. Did you try to call him or?
Yes, Chair. No, I couldn't get hold of him.
All right, in the light of that information, we tried to get hold of Mr. What's his name? Mr. Martin Pretorius from Laerbur School, General Albert's Primary School. But anyway, let me take this opportunity to thank all people who responded to the invite and availed themselves to make a presentation representing their organizations. And the last person who was representing her own self. So we thank you all for having made your time to talk to us. We value your efforts to help us, look deeper into the basic education in our country. We've talked about a lot of things, from infrastructure to to garden schools also, all that went into the presentation, and we thank you. Thank you so much for having made that. Honorable members, let me just check with Noltando. Meskaka, is there some other thing that we need to discuss in this before I close the meeting, this hearing?
No, Chair.
In the absence of any other issue on the agenda, thank you very much. And our meetings are always open to the public, and you will be able to follow how the discussions will go forward from here. Thank you very much, and this meeting is adjourned.
Thank you, Chair.
Yeah.
Thanks, Chairperson.
Recording stopped.
Thank you, Chair.
Sekeran says Alman Moch. I guess Moch so Samocho.